around digital markets. The first one is the regulation of competition in digital markets, and the second one, the implications of e-commerce in labor relations.
A couple of things before we start. As an introduction to the Progressive Policy Institute, or PPI. We are a non-profit think tank based in Washington with several overseas offices. We have been operating for 35 years since our foundation in 19. Intense interest in challenges they pose to governments making law and making policy. So we are regularly sharing ideas and experience with the United States of factual background before experts. Digital economy is now very large. I've seen a Brazilian government report suggesting maybe as much as 21% of Brazilian GDP. I've seen a World Bank estimate of 15% of world GDP and a growth rate 2.5% faster, or 2.5 times faster than that of the world economy in general. To move ideas, to move information, to move financial services around the world is growing very, very rapidly. This in turn means the opportunities that digital technologies offer are rapidly expanding. The questions they raise for governments and for parliaments in developing law and regulations are growing very fast. The opportunities and the questions they raise for employment and workforces are much the same. And we are so lucky to have such a distinguished group of panelists from PPI and from our partners and from friends and interested people here at the university today. So thank you very much to everyone for attending, and I look forward.
Themes. In Brazil, like the rest of the world, the regulation of platforms is a key issue in many fields, like the civil liability, but also the two central themes of this symposium, the regulation concerning labor markets. We have an important and very controversial judgment of the Tribunal of Labor Issues in Brazil concerning individual transport, but also the theme of the competition regulation of the platforms. I will not talk about the themes because we have some speakers among us. I will be a speaker and I will talk about competition regulation. So my role in this opening desk is only to welcome you and to describe the honor of the University of São Paulo to welcome you in this symposium. Thank you so much.
Well, thank you very much. So I would like to welcome everyone. It's a pleasure to have you here. Thank you so much for joining us for the Symposium on Digital Markets today. It's my great pleasure to welcome you at this round table on regulation and of digital markets and global competition. Actually, the digital advent of the digital economy, has really certainly transformed the ways firms compete, how consumers behave, and even how markets work. We can say for sure that for the most part, the effect has been hugely positive, leading to innovation, reductions on transaction costs, and greater choice for consumers. However, the emergence of powerful platforms, the importance of data, and the continuous use of algorithms have given rise to strong competition concerns, such as possible abuse of dominance. In fact, for those who are following the discussions, the debate was torn between the ones who advocate extreme measures, like breaking up today's tech giants, regulating their allegedly anti-competitive conduct, or the ones who questions if antitrust and regulatory experts are wrong to view big techs as monopolies that deserve to be regulated. Some call for a specialist agency to regulate the tech giants and a quick move toward the regulatory approach in a call for ex-ante asymmetric competition rules. Our panel will explore the global digital competition landscape, discussing some of the initiatives going on in different jurisdictions and comparing regulatory toolkits with a focus on the regulatory approach to digital markets, addressing possible drawbacks of European Union Digital Markets Act style regulations. The DMA came into force, as you all know, in May 1st this year. In the United States, the Congress is still debating the pros and cons of the American Innovation Choice Online Act, a bill that, if approved, will authorize FTC and DOJ and state attorneys general to challenge self-preference in online platforms of certain size, as defined in terms of annual sales, market cap, or active users. We will also address the current state of the debate in Brazil and the Bill 2768/2022, inspired in the DMA, as well as the merits of global propositions for regulation in the digital sphere to foster competition in the digital markets. So, as we can foresee, it will be a very interesting panel. And to debate all these issues, we have the pleasure and the honor to have with us today Ms. Malina Daly. You can come here, please. Technology policy analyst with the Progressive Policy Institute, where she works on issues relating to social media and the internet and technology sector. Prior to joining PPI, Malina worked as a policy analyst for NetChoice, where she focused on state and federal legislation that would impact technology companies, and with an emphasis on policies relating to antitrust and content moderation. Also, we want to host Mr. Cesar Matos, legislative consultant in Brazilian House of Representatives, And he's also an economist. He holds a PhD in economics from the University of Brasilia, and he's a former commissioner at the Brazilian Antitrust Authority, CADE. Matos also contributes to the drafting of the Bill 2768 of last year. Our professor, Roberto Pfeiffer, well known by everybody. He's a professor here at the University of São Paulo Law School, holds a PhD in economics, in law, and is also a livre docente from USP. He's a state attorney for the state of São Paulo, is a former commissioner at the Brazilian Antitrust Authority, CADE, and a former executive director of São Paulo's Protection and Consumers Defense Foundation, PROCON. And last but not least, Mr. Victor Fernandes, that is a commissioner at Brazilian Antitrust Authority, CADE, and a professor of economic and competition law at IDP in Brasilia. He holds a PhD in commercial law from USP. He has also worked as a legal advisor to the Office of Legal Affairs of the Cabinet of the Brazilian Presidents, and as a chief of staff of one of the judges on the Supreme Court of Brazil. Welcome, everybody. Let's begin. César, falta você vir pra cá. Tem cadeira, não? É. Peraí, essa cadeira aqui. Malina. No, that's okay. You can begin? Yes.
Thank you all for being here. So the Progressive Policy Institute has done a lot of work over the years on both competition regulation, the regulation of digital markets. Sorry, can I? Apologies for that. We'll try this again. PPI has done a lot of work over the years on the regulation of digital markets, competition, and the impact that the tech industry has really had on a global stage.
Try that one.
Do I want to try this one?
Maybe.
All right, is that? All right, we'll try this again. So, we're thrilled to be here in Brazil talking about just the impact of the tech sector on the Brazilian economy and how we've seen regulation around the world really impact the type of conversation that you're having in Brazil, that the European Union has had with the Digital Markets Act, and that the United States have had with the American Innovation and Choice Online Act, among other antitrust proposals which have been going through the United States Congress. As PPI has really been looking at the digital markets over the past few decades, the world has really focused on trying to promote competition in these markets, and there's been a shift in a lot of world governments to try to do this in a way that is similar to the style of the European Union. The European Union was kind of the first to enact these regulations and move forward with a specific style, and the way that they've chosen to do that is really based on the size of companies rather than traditional antitrust enforcement, at least in the United States, which is really based in an assessment of market power for companies rather than just size alone. And since the European Union enacted that last year, we've seen a lot of proposals, both in the US and around the world, copy that style, basing their regulation on market capitalization or number of users for digital platforms. And PPI as a organization that's really focused on economic growth and also the benefits that the growth in the economy can bring to society. For example, we do a yearly report just on amount of investment by private companies in the economy, and tech over the past few years has really been a leader in that number. We're seeing investment, we're seeing the benefits, we're seeing jobs, as you may have picked up our report on the app economy. There is tangible growth in these areas, both in the labor market and then also in just the size of the tech sector, and this is true in both Brazil and the United States. So PPI has generally rejected the strategy that the Digital Markets Act has presented for digital regulation. The regulation proposed in the United States, again, took a similar approach and was eventually rejected by Congress. They did not bring it to the floor for a vote, and that was for a reason. There was a decision basically made that this is not, at this time, the right type of way to regulate digital platforms. And that's not to say that there's no competition concerns. There have been plenty of cases brought through the judicial system and through traditional antitrust enforcement that are seeking to address some of these issues. But the just simple, like, size big is bad approach to regulation was not necessarily where the US wanted to go with that. And so I don't want to speak too much about Brazil, because obviously there are other experts on this panel that can speak to that, but the International Trade Administration has recognized Brazil as being the 10th ranked country in terms of the global information technology market, and the 5th ranked country in terms of the largest fintech market in the world. There's enormous potential here. Sorry about that, we can try that. That was louder. There's enormous potential here, just both in terms of the growing tech sector and the ability for that tech sector to really flourish in the global market. And in a time where we have seen, productivity growth in the United States rise while productivity growth in the European Union has fallen during a period of more intense digital regulation, and while we've seen the tech sector in the US or in Brazil really flourish, we want to provide a different kind of perspective than the size-based regulation that is really being proposed in a lot of countries right now in terms of how to deal with digital platforms. So thank you for having me here today. I am excited to have this conversation and look forward to debate.
Great, thank you, Melina. Now we'll have a presentation of Mr. Carlos Baigorre, the president of the Brazilian Telecommunications Regulatory Agency, Anatel. He was supposed to be here, but he had a problem, and then he will be with us online, okay? It's important because in Brazilian bill, the bill 2768 of 2022, Anatel was designated as the regulator for digital platforms in Brazil. I'm sorry.
Good afternoon, everyone. First of all, it's a great pleasure to be here today with such important people discussing the competitive landscape in the digital markets. First of all, I would like to salute Malena Deli from the Progressive Policy Institute, Cesar Matos from the Chamber of Deputies, Victor Oliveira Fernandes from CADE, and Roberto Pfeiffer from the Faculty of Law of the University of São Paulo, and also our moderator, Bianca Moliconi from the Legal Grounds Institute. Well, when we look to the competitive landscape regarding digital platforms and digital markets, I think that what we can see in a consensus worldwide is that authorities are concerned about the amount of market power that a handful of companies have accumulated in the last years. So we have been seeing these discussions. They're happening right now, in fact, in Washington, with FTC presenting cases, antitrust cases against Amazon and against Google. We have been seeing this in Europe also, in discussions with not only on the antitrust context, but also with now the DMA process and the DMA legislation, with more with a ex ante regulation of this market. So I think that we can say that there is a consensus regarding the potential problems and potential behaviors that these companies have been using and having in the last years that generated a big concentration on the digital markets. And another thing that we can see when we look to the telecommunication perspective is that this huge concentration that we see has been also generating effects in the telecommunication networks. This is also a big discussion that's happening in Europe that's called the fair share discussion, in which telco operators say that they are having more than 50% of their traffic being generated by this same handful of companies, and asking for some kind of symmetric and for some kind of compensation and or sharing the investments for deploying new networks and expanding those networks. So what I can see is that the situation de facto is not right now one in which we have the internet ecosystem concentrated in a few companies that are concentrating the market power, and these are generating concerns not only on authorities but also on other sectors and other segments that have a good symbiotic relation with them. And the difference that we see in the difference in the administrations in Europe and in the US is basically the approach how to deal with that. So in the US, what we've been seeing is an approach based on the antitrust law, so really focused on the FTC and initiatives. And when we look to Europe, we see that you have a complementation. First of all, of course, you always have the antitrust body involved in this kind of discussion to try to tackle specific conducts and behaviors that may be harmful for the whole ecosystem. And the other side, and the other hand, also what we see in the Europe is now they are discussing through the DMA process to have not only an antitrust angle with that, but also a traditional regulatory approach for this kind of for this market. Once that this market has a lot of supposedly has a lot of market failures that traditionally are dealt through regulation, through economic regulation. So we are talking about market power, we are talking about externalities, network externalities, we are talking about interoperability, we are talking about asymmetric information, lack of incomplete information. So all the traditional market failures that we see in traditional markets, we see it right now in the digital markets. So the discussion is what should be the approach. Here in Brazil, we have the antitrust law. CADE is the central agent, the central body of the government to deal with all this law, the Brazilian system of antitrust. So CADE has the authority, and I think that should maintain having the authority to deal with conducts, to deal with all these abuses that may happen in the digital market. What's happening in the discussion? What's the discussion that's happening right now in the Congress, in the Chamber of Deputies, is a proposal of a law in which it expands this approach from the Brazilian state, not only to be focused on antitrust, but to have also a traditional regulatory approach. So in the same way that we have today in the telecommunication market. The telecommunication market is regulated by Anatel, by the telecommunication regulatory agency, as is the FCC in US, and you have a lot of regulatory agencies, the national regulatory agencies, all through the European Union. So in telecommunications, we have this tradition. But not only that, when we have a specific, the telecommunication law specifies that in cases in which you have problems from an antitrust law, from the antitrust perspective in the telecommunication market, the jurisdiction over these cases is from CADE. So you have a coordinated role between CADE and Anatel. So if you look in the back, if you look in the main cases, the main mergers and acquisitions that happened in the last years, they need to be approved by CADE and by Anatel. They are assessed by CADE from an antitrust perspective, considering the antitrust law, considering all the elements, all the conditions that are assessed by CADE, and they are assessed by Anatel from the regulatory perspective. So we assess it from spectrum perspective, from perspective of the telecommunication market, and both agencies, CADE and Anatel, have been really harmonic in how they deal with the telecommunication market. And I think that this is a good point for we start thinking how should be in the digital market, because again, CADE has a great experience, a great knowledge about how to deal with specific cases, with cartelization, with abuse of market power. But Anatel has also great experience in how to create conditions, ex-ante conditions, to promote competition in the market. We have been doing this with telecommunication markets for the last 25 years, and sincerely, I think that we have been doing a great job. If you look what happened with broadband access and broadband competition in the last 10 years through our plan of promoting competition, that's basically inspired in the European framework for for assessing market power, identifying providers with significant market power, addressing asymmetric remedies. So what we have been seeing in Brazil in the last years is a complete transformation of the competitive landscape, thanks to a really good and well-designed and well-implemented regulatory policy to promote competition. So I think that in the same way that we have been successful in the telecommunication market, we can be successful in the digital markets with a coordinated, harmonic, cooperative approach from CADE in the antitrust perspective and Anatel in the regulatory perspective. Because when we look from the regulatory perspective, as I said, we have basically the same market failures. We have market power, we have problems of interoperability that in the beginning of the regulation of the market, of the telecommunication market, was the interconnection discussion. So basically all the same market failures we have in the digital markets, in the telecommunication markets. Of course, the remedies, they cannot be just transplanted from one to the other. But I think that the mindset it's based on the EU framework for telecommunication, for electronic communications regulation, and the DMA is basically the same mindset, which is the mindset: identifying a relevant market, identifying if in that market there is a player, a company with significant market power that has a considerable risk of abusing its market power, then addressing asymmetric regulation, asymmetric remedies to mitigate the risk of this abuse of market power. And all this assessment made considering the market failures that we may see in these markets and all the value chain of these markets. So this mindset that is present in the EU framework is basically the same mindset that we have in the DMA. Instead of calling companies with significant market power, they're calling gatekeepers. So it's basically the same mindset, and this mindset we already implemented here in Anatel in the telecommunication market, and we have been really, really successful with it. And I'm quite sure that we can have the same success if we use the same mindset and the same framework to address the potential problems and the potential abuse of market power that we may see in the digital markets. So again, I think that the same here in Brazil, we have a saying that's like this: you don't change a winning team. So if the team is winning, you don't change them. So basically, I think that we can use the same idea here when we talk about digital markets. We have a winning team in telecommunication markets. Anatel dealing with ex-ante regulation, creating and promoting competition, and CADE dealing with a specific case with an ex-post approach in which M&As, problems that coordinations, cartelization are dealt specifically in that case with CADE. So Anatel with how to say, a preventive approach, and CADE with a repressive approach. And I think that both agencies, both institutions, CADE and Anatel, are doing a great job in the telecommunication market. We have been seeing a huge transformation that's getting better price, better coverage, better conditions, better quality. And I think that we can use the same strategy, the same mindset to make also a great transformation in the digital markets and create better competitions, better conditions for competition. And who can imagine even the new companies, Brazilian companies, being important players in these digital markets. So I think that's my main vision. And thank you again for the opportunity to be here with you today.
Thank you for Mr. Begorri for his presentation. And now we'll follow with Mr. Victor Fernandes. Let me just put your presentation here.
Thank you, Bianca. And first of all, I would like to thank you for having me here. I'm very glad to be here. So I'd like to thank the organizers of this conference, especially people from the Legal Grounds Institute. It's a great pleasure to be here alongside with my esteemed colleagues and Cesar Matos, Professor Pfeiffer, who was my esteemed professor when I was a law student here, and our colleague from the PPI. So I planned to dive a little deeper about the Brazilian draft. I think that the sound might be a little bit louder and loud, and if you could just okay, no, it's okay. So I plan to, yes. Oh, I think now it's better. Maybe I was planning to give you a broad overview about the Brazilian draft. We are currently discussing ex-ante initiative in Brazil, which is inspired in the DMA, as you know. But first of all, I think that it's important to set the stage a little bit and find some common grounds on discussing what are these new ex-ante initiatives and how are they different from the perspectives that we have in the very traditional realms of competition policy and economic regulation. And I think it's very important to start from the beginning by saying that we are now facing a brave new world when we talk about these new ex-ante initiatives, such as the DMA, the Article 19A from the German competition law, and so on. And it's important to be aware that we are not talking about here some kind of renowned essential facilities regulation. And I think that's a point that I should emphasize here. When we take legislation such as the DMA, there is a very different perspective on economic regulation that is being pursued here. First of all, the DMA is not about correcting market failures in the sense of more traditional economic regulation theory. There is this very interesting paper written by Professor Carmelo Senamo, which is the director of the Digital Platforms Institute, and it is entitled "The Digital Markets Act is not about market failures, but rather about ecosystem failures." And I think that's the point of the DMA. We are talking about some sort of a new reality which is coming up from the digital ecosystems, where you have some huge platform which is called an orchestrator, which is the gatekeeper, and this guy has the power of embracing new forms of abuse of power in face of business users and end customers. So that's a very different perspective from what occurs in more traditional economic sectors. And that is why we have currently a very in-depth discussion in competition law academic sphere about what is the legal nature of the DMA. So professors such as Professor Heike Schweiste, which was one of the authors, the co-authors of the European Union regulatory experts, for instance, she says that the DMA is about competition policy beyond antitrust law. Another interesting professor, Professor Nicolas Petit, for instance, he says that the DMA is about a competition hand in a regulatory glove. And the thing is that when we see these legislations, we can see, for instance, in Articles 5 and Article 6 of the DMA that almost all of the obligations, the ex-ante obligations that is designed upon there, are based on ongoing or past antitrust investigations. So if we see, for instance, the Article 5.1, we see as a ban on self-preferencing, which is pretty much the Google shopping case. And we can move on and talk about several of these obligations. So I think that we should kick off by saying that this is not a new form of traditional essential facilities or public utilities regulation, and that must be clear till we grasp this new spirit of this legislation. So I think that now we can move on and talk a little bit about the Brazilian draft. The Brazilian draft, which was presented before the National Parliament on November last year, is very inspired by the DMA itself. And when we read the explanatory memorandum, which is written, penned by the Congressman João Maia, we can see that there is a huge signalization that we would like to integrate in Brazil some sort of DMA legislation. But on the other hand, we have the intention to pursue maybe some sort of a Brazilian unique approach. And I think that, and I will try to give you a broad overview about this proposal. I think what is the main problem with this proposal? I think this proposal has a huge merit, which is to discuss a way moving forward competition law and competition policy as we know it in Brazil. But on the other hand, I think that there might be some shortcomings and some pitfalls that we should avoid, and I expect that the Brazilian Congress can address these problems as the proposal is being assessed. So the first point that I would like to mention, if you could pass, Bianca. Thank you. So the first point that I would like to emphasize here is that we are not very clear about what are the goals of this proposal. When we look to the international counterparties, for instance, when we read the DMA, it's pretty much clear that the DMA is about two intertwined goals, which is contestability and fairness. And so here we can see that this is some sort of unique legislation, because contestability is the ability of newcomers, of new entrants to impose some sort of a threat on these incumbent agents, which are the gatekeepers, which are the main target of the DMA. And when we talk about fairness, we are talking about that there is some sort of a disbalance between the rights and obligations of the DMA and especially the business users, and then the DMA is trying to level the playing field in this kind of economic relationship. So in the sense, when we look, for instance, to fairness as such a goal, we could, for instance, say that fairness might be much more related to the perspective of some sort of a consumer law in the B2B perspective. There's not pretty much like economic regulation. But when we see the Brazilian draft, we have two broad lists of goals and principles in Articles 5 and Article 4, which are very broad, and some objectives such as reduction of regional and social inequalities, access to information, knowledge, and culture. So it's not very clear what is the main goal of the proposal, and if our proposal is to follow a DMA-like legislation, I think it's very important to assert that our goal is pursue contestability and fairness if it is our decision. Second, I think that we did not have provided any qualitative meaning on the notion of platforms holding essential access control power. So this concept is pretty much based on the idea of gatekeepers, of course, but when we read the DMA, there is a lot of qualitative components behind the idea of the gatekeeper. And I think that's a point that we should really discuss here, because as the concept or the idea behind the gatekeeper is moving far apart from the traditional notion of dominance, we might have a very different perspective on what is going on. So when we see, for example, initiatives just like the UK proposal or the German new legislation, we can see that they put a lot of emphasis in the qualitative dimension of the regulatory target. So in the UK proposal, for instance, there is a long public consultation process in order to designate a term as a SMS, which is a strategic market status in the UK proposal, for example. And in the Brazilian proposal, I think that we are only relying on a quantitative criteria, and we do not have, for instance, such as in the DMA, the possibility of the firms to rebut this designation. And I think that we should consider this option, because otherwise we are running to a very raw material assessment of what is a gatekeeper. And I think that the problem, which might be the most critical issue here, and I'm trying to not excess my time here, but I think that the main problem with this proposal is about the enforcement strategy. When we see the different perspectives that are coming up in the American Innovation Online Choice Act, in the UK proposal, in the German new legislation, we can see them as different perspectives on what should be the optimal enforcement design. For example, the DMA has two different perspectives on that. When we see the Article 5, we see just more per se like rules, which are the obligations that are self-applicable. On the other hand, in Article 6, we have the obligations that are being further specified by the Commission in the next upcoming months. So we have just two different perspectives. Maybe the first one, Article 5, is much more like a per se rule. On the other hand, we have Article 6, which might be subjected to further discussion with the Commission itself. In the UK proposal, I think that the enforcement strategy is even more flexible, in the sense that the Digital Markets Unity will provide a code of conduct that it will be specific to each firms that are designated as MS. So I think that there are very different perspectives on what is the best enforcement strategy. When we look at the Article 10 of the Brazilian proposal, you can pass another one. When we look at the Article 10, we can see that there are 4 very broad obligations, and it's not clear upfront whether these obligations are or not to be interpreted as a per se rules, or if there is any sort of justification that can be posed by firms on these obligations. So the first obligation is a very broad one, and it is about the transparency and supply of information from the firms to Anatel. The second one is a economic and a non-discriminatory treatment in the provision of service to professional users, which is pretty much like a ban on self-preference, very similar to what we see in Article 5.1 of the DMA. And then we have this, and this for me maybe the most confusing and dangerous obligation, which is the proper use of data during its activities. I think that the intention behind that would to be to prohibit some sort of cross-use of data, which is pretty much what is written in Article 5.2 of the DMA. It comes down to the discussion about the Bundeskartellamt versus Meta in Germany. But as far as it in this current written, it's a very broad obligation, and we do not have any sort of guidance on how this obligation will be implemented by firms and how they are going to be assessed by the regulatory agency. And finally, we have some interoperability and data portability remedies. And here as well, we have to be fully careful about implementing these measures. And so in this point specifically, I would like to pose a very different perspective from what occurs in digital ecosystem and traditional public utilities. For example, when we are in the realm of traditional public utilities such as telecommunication legislation, it's much more easier to impose interoperability or interconnection remedies. That is not the case when the asset involved is data. Because here you have a lot of worries about data protection. You might have a lot of problems regarding how to implement data interoperability remedies and so on. So this kind of parallel, it must be drawn with in a very cautious way. And I think that we should see this, especially because data portability or data interoperability might be not so useful in providing more competition across each type of the market. So for instance, when we say about social networks market, it may be that you have some sort of interoperability remedy or data portability, but in the end of the day, what is being provided by you as a service, which is the attraction of the digital platform, is not based on your RAM data, but is based on the artificial intelligence and all the mechanisms that are being adopted before that. So I think that we have to discuss more about how each one of these proposals is going to be adopted. So just to finish here, I think that we have some sort of a lack of clarity on the regulatory goals. Maybe we might having a misunderstanding about what is the unique legal nature of ex-ante initiatives. There are some trade-offs involved in moving to an ex-ante approach. So we have to assess where the risks, the pros and cons of moving to a more ex-ante perspective, such as the DMA, or maybe we should have a more flexible approach, such as the UK proposal or the German law proposal. So I think that it must be discussed in depth by the Parliament right now. And finally, I think that there is sort of a lack of procedures. So when we read the DMA, it is pretty much about procedures and how the legislation is going to be implemented, how are the spaces that firms will have to put forward their defenses. The DMA itself provides for a regulatory dialogue between the Commission and the parts. So I think that these procedures were not very considered in the Brazilian proposal. So I think that's my main observations about the Brazilian proposals. But I would like to hear from you what are your perspectives. I'm eager to discuss this with you more. Thank you.
Great, thank you, Victor. Thank you, Victor. Now we're moving to Professor 5. Okay.
So, good afternoon for everybody again. It's a great. First of all, I would like to thank the invitation to be in this desk with dear and estimated colleagues like Victor, my former student, but a brilliant commissioner of CADI, Malina of this very important institute, Cesar Mato, my old friend and an important former commissioner, an important professor who is one of the writers of this bill of law, and also my colleague from Anatel. It's a great pleasure to be here. It's an honor to University of São Paulo to host this symposium and this great audience. I see a lot of friends and experts in the audience. So this is the summary of my speech. I will talk very few words about the competitive dynamics of digital platforms, and I will address the trade-off to regulate or not to regulate. But I'm in favor of regulate. But and I will. Yes, I will talk very few words about some international paradigms, and I will address some aspects of the bill 2768 and make some suggestions. It's not necessary to talk so much about the competitive dynamic, but it is important to see that there are some structural problems that lead to concentration. And these particular problems that are very different from essential facilities, I totally agree with Victor. It's totally different, and it's not the same problems with all the markets. All the digital markets, they have some kind of difference between them, but the main problem is that there are some network effects. There are some very huge economy of scale, of scope, and the very many of these markets are no price, and they are very data-driven. They are very data-driven because they collect the collection and processing of is at the heart of the digital platform business model. So they are very different from the traditional agents. And we have different remedies to handle with them. And I'm totally agree that the remedies like the essential facilities are not pretty good to handle of it. And they are, I call it then serial buyers because they buy and buy and buy and buy, and no one of the acquisitions of the platforms are challenging by the antitrust agencies. No single one. The trade-off between regulate or not to regulate, I think it's not more a trade-off. I think there are convergence to the importance of regulate this, but in combination and not opposition with other measures like the application of antitrust with better adapted tools, the institutional collaboration between agencies like Anatel, CADI, but also in the field, for instance, of data protection with the national authority, with consumer agencies, bodies, and so on. But it's important and interinstitutional collaboration. It's very important to handle with this kind of problems. And the third and more controversial issue is the ex-ante regulation. But I think it's not an opposition between these three tools. I think they must be, or they should be, combined to a better approach to the problems, or the special problems with digital platforms. And this is the debate in the world. So, as you know, as mentioned, in Europe we have the DMA, we have the first experience with the German reform of the competition, German competition law. We have a debate in United States, and we have a kind of regulation in China, for example. So we have some experience that it's important to see this experience and to adapt this experience to the Brazilian experience, or to the Brazilian legislation. So I not talk in depth about DMA. I don't have time for it, but it's important to discuss the methodology of the DMA, as they assume that, for instance, they are a semi-flexible document which combines a set of self-execution obligations and obligations with regulatory dialogue, like Article 5 and Article 6. It's more or less this kind of mix of flexible and semi-flexible document. We could call them as antitrust asymmetric. Why antitrust asymmetric? Because it stipulates several requirements for a platform to characterize as gatekeeper, a special kind of platform. And in the event that the European Commission decides that it falls under such concept, and as Victor said, they could contest their, because they have some quantitative but some qualitative requirements. If they are characterized by European Commission as a gatekeeper, it falls. They have to accomplish a series of special obligations, different from other kind of platforms that are not characterized as gatekeepers. So it's an antitrust asymmetric treatment. Bem, I will not talk so much about German, but it's the same approach with another name. It's significant activities or a paramount platform, but it's the same strategy. It's the same strategy. They will have some obligations if they are characterized as paramount platforms. The China, I don't have time to talk about China, and to talk about China we have to contextualization so much, but they have an interesting regulation as well. But I think the audience is interested in Brazil, and Cesar and Victor will talk in depth. But this is the bill of law 2768. I have to I would like to congratulate this initiative. I think it's very, very important and very, very well in a very, very well initiative. I think it's very important to start a conversation and a discussion about the theme. So, but they have some problems, and I very, very, I like so much this bill, but I will point some problems with very respect with Cesar, the father of this bill. The first problem is about quantitative. I think it's very important to have quantitative parameters, but one of my suggestions, like Victor, that they have to combine quantitative with qualitative parameters. The most objective possible, because we know the problem of security, but it's important to combine both of them. But the quantitative parameters are very low, in my opinion. It's only the turnover is only 70 million reais. We will accomplish a very set of platforms, and I don't think this is the objective of this kind of law. We have to focus on a few number of platforms and not a large number of platforms. And 70 millions of turnover, in my opinion, is a very low approach, and comparing with German regulation or DMA regulation. So, and the second concern is to put some kind of qualitative aspects, and it's important to the platforms to challenge this this characterization, because they will have to accomplish a set of different obligations, and they can. It's important for they could challenge the designation. I will not talk about the Article 10 again. I don't read again, but I totally agree that the kind of obligations are very broad, and already can be extracted from competition law, and the interpretation of competition law is not so new obligations. But I think more about it. It's important to have some vague if you combine with the single paragraph that lead the agency or the regulator to make some more specific obligations. But in the juridic sense, it's very dangerous to agency to put a specific obligation. I don't know how the tribunals are interpreted, if it's legal or not legal. But I agree that are very broad, and it's much more to specify better or in deep with the significance. I totally agree with Victor. And I suggest, if as a GMA, if it's not good to put some specific obligations, but I don't like so much the per se rule. I like much more the Article 6, not the specifications. I think in the Article 5 are very important conduits, are very important obligations, but I don't like so much the per se rule in Brazil. I think it's much more better the same kind of conduct, the same kind of obligations and prohibitions, but with a sign of the reverse of burden of proof, for example. They are prohibited to make this conduct. They have some obligations, but they could prove that these conducts or obligations are not against the competition environment. So I think I totally agree that it's important to put some obligations and prohibitions more specified, but not in a per se rule. It's in a more flexible way, like, for example, the discussion in Britain. I think it's better. It's a better way. Concerning the enforcement strategy, I think that's a very huge problem with sanctions. Two kind of problems. The body that will be responsible for the sanctions, because much of the nature of the conducts that can be penalized are very, very similar with conducts against competition law. So we can have a conflict of attribution, and we know in Brazil that it's a very it's a very sensitive it's a very sensitive issue, and the tribunals will will see it, and we will have prosecutions that will lead to many years to decide if it's competence of CAD or the other authority. So it's the first nature of problem. But the second problem is the amount of the fine, because the amount of fine is only 2% of the turnover. And for instance, in the Brazilian competition law, the fine could be 0.1% to 20%. The maximum fine is 20% of the turnover. So the maximum fine would be low than the maximum fine of competition law, and it's very rare, because if you have an asymmetric treatment for some kind of platform who have a huge market power, they will receive a fine low than if the same platform or other platforms will fine based on the competition law. And this is a kind of problem. I think it's very important. So and another kind of discussion is about it's concerning regulatory body. Who will be the regulator? In the ideal world, maybe a new agency with multidisciplinary knowledge, but we have some budget constraints, and we have to see it. It's very to be pragmatic, and we have problems with our budget, our public budget. After listening my colleague from Anatel, maybe if you the second best will be an actual body with new new attributions. So after listening it, maybe the better solution will be split, the attributions, and so the accent regulation could be assigned to Anatel, but with strong and in the law obligations to listen another bodies. But the enforcement, the fines, maybe it's better to keep it with CAD to avoid some kind of conflict of attributions, and to be more harmonized the amount of fine. Maybe it could be a solution, because to assign to CAD ex-ante regulation is very complicated, because the body, the authority has few persons, and it's not their job, But we can think in a split. But the experience I respect so much, Anatel, but experience with the enforcement of competition issues not so good in the fine. So I think that the methodology of DMA and German law should be reproduced, identification of the dominant platform, but with quantitative and qualitative problem, and we have to see this excessively low turnover. And I'm very suspect of it, but I have inclusion of personal data concerns beyond the data portability issue. And mandatory submission of all mergers of gatekeepers for prior assessments by CAD. This is more than DMA do, because DMA only oblige these gatekeepers to inform. But I think it's better than inform to make submission of all mergers, no matter the turnover of the enterprise that are acquired, because they are serial buyers, and it's important to see all of the acquisitions of these platforms. And if you handle with a few platforms, no more than 10, I think, it's not a problem. It's not something that will put in very, very high number of acquisition. And if it could be better than change the turnover, or change the thresholds for all the sectors, no? Maybe only for this sector, no? And the revision of sanctions. So it's my words. I thank you very much for your attention, and to be here with you in this symposium. Thank you so much.
Thank you very much, Professor. And now let's listen to the Now let's listen to Mr. Cesar Matos, named the father of the child, to see his remarks.
Okay. I'd like to first to thank Legal Grounds and Progressive Policy Institute for being here in this event. Very stimulating, and I'm getting used to the fact that every time that I'm going to talk about this issue, I'm the father or I'm the creator. You know, the Frankenstein is yours. You know, so. And sometimes it's not that easy, but anyway, I don't talk on behalf of the bill. I'm just one of we work this with. I work this with Anatel. Anatel was also very responsible for this, because I think they have this in mind a lot of time. And then they were already thinking about it. That is what demand of a congressman. And I've just, as long as I worked before the Chamber of Deputies, so I was in charge to make this this work. But anyway, I'm not responding for the bill. Anyway, I think that it's important to come back to the basics of the basics of economics. As I'm an economist, I think it's good to know. And I have a question for my friend about this. What is the main competition issue in digital markets? Everything that we see in the literature on the cases, it's a vertical. There's a vertical relationship between two markets, and then there's a sort of vertical restraint that occurs between one segment of the market and the other segment of the market. That we can call the first one as the main business of the incumbent, and the second one you could call an adjacent business. It depends on the author and how they give names to the segments of the market. The fact is, the adjacent business they count with an input from the main business of the incumbent, and this input is access. For some reason, you need access for the main business of the incumbent, and so it creates a dependence from the adjacent business to the main business of the incumbent. So if you think about Amazon, we think about Google, we think about Apple, Microsoft, we have this sort of relationship between those two players. So it's not quite different from any vertical case in CAGI. It's very similar to the typical cases, and mainly in infrastructure. So when I read any paper on digital markets, I just feel that I'm reading a different form of vertical foreclosure coming from infrastructure sectors, where it's very usual and where we bring most of the concepts that we are using here on digital markets. So the fact is, we have discriminatory strategies in the provision of the input access to third parties, particularly this conduct called self-preferencing. That is the most quoted conduct in this sort of market. And you have two sorts of conducts that you have to pay attention. First, the main business of the incumbent wants to leverage its market power to an adjacent business. And sometimes they discriminate competitors' adjacent business because they want to prevail on this second market of the adjacent business. They don't have to provide access, don't want to give an input in the same basis that they will provide to himself, in the sense that they say they self-prefer himself rather than anyone else. Okay, because he wants to monopolize adjacent business. So it's very typical of antitrust analysis. With all the discussions, all the debate we have in antitrust about vertical foreclosure, that is not a trivial. It's far from a trivial discussion, because we have a lot of theories and a lot of controversies. The Chicago school and the structuralist school. We are not going to bring here to discuss. But anyway, that's the first one: extension of market power from segment 1 to segment 2. Why? Because adjacent business require an access to an input on the main business of the income. You can take the example from Google horizontal search versus vertical search. So to have access, the vertical search need. This is mostly the case of Google Shopping. Is about this. So we have Google Shopping benefit itself from that's a vertical. This a vertical search tool, and it it was benefit by the access, direct access to the main business of the incumbent. That was the horizontal search tool of Google. So Google was able to discriminate other companies. Here in Brazil was the case of Buscapé. CADE considered Google innocent in this case. And I don't know if you agree with this. I thought I knew the answer. But anyway, this was the extension of market power from 1 to 2. And the other way around also. You have the other it's less quoted, but you also have the fear of the main business of the incumbent to say, well, adjacent business is very close to the main business, so sometimes a guy who's developing himself on the adjacent business, he can migrate in some point of time to the main business of the incumbent because he got some knowledge, learning by doing in the adjacent business, so he got more used to my main business, so he can invade my business. So I feared about this. I don't want him to develop. But we from antitrust agency, we want this to happen. So we like to have the other way around as well. So we have two main reasons for this to occur. So this is something that is very basic on antitrust theory and economics. Well, what the US antitrust experts think about this subject? So sometimes we talk about the consensus. Baigorre, he told about a consensus on this, that this is a problem. But when we look at I think perhaps the main document, now historical document from 2020 from Lina Khan and in the Senate, it's the 450 pages report on digital economy and antitrust, and you have some papers that provide the support to write the report, and they put this in the site as well. And we have two papers and very starred experts on antitrust from one side and another, and they conclude basically the opposite things of this matter. First of all, the first guys that you find a guy that I didn't put the names, but for who studies antitrust, you see that the main guys of antitrust is in the second and the first and the second group as well. So the first they say the U.S. markets are more concentrated, competition is weaker, antitrust law as interpreted and implemented are inadequate to challenge growing market power, and this happens mainly on digital markets. The other group say the U.S. economy, including the digital sector, is very competitive, innovative, and serve well consumers. There is no problem at all with antitrust legislation, and there is no trend at all, no tendency to a growing market power, and certainly is not the case that any conclusion on the opposite reflects an incomplete or incorrect understanding about the economy and economic literature in the last decades. That's precisely the opposite of what the first group say. It's lawyers and economists, not only economists. So the fact that in some there is no consensus at all, mainly in the United States or Europe or in the international literature. We have a gray area, gray with E, not A, about big tech's conduct, and there's this handbook on competition policy that they put it very clearly. That's a typical case of false positive risks and false negative risks that affects perhaps every state intervention policy. But in the case of digital markets, perhaps it's really very, very strong. First, the risk of that state intervention will undermine Schumpeterian entrepreneurial spirit of some companies. We can say that in the case of digital markets, when you think about Facebook, when you think about Google, all of those companies, they are not lazy fat cats. not lazy fat cats at all. They're not these guys that are accommodated incumbents. I have my market here. I don't need to do anything else. I'm very well in life, very accommodated, very easy life. No, they are not these guys. They are not these guys. So there's a very high risk, and we have to recognize this, mainly the regulators from a competition agency or even sectoral agency. You have to be aware, very aware, that we are not supposed to undermine the competition coming from the incumbent is as important as the competition coming from the entrant. I'm not supposed to discriminate incumbents. They are as important to competition as entrants in any market. But in this market, I think we can't say that incumbent is really a guy that, he doesn't do anything for innovation. We are dealing with Schumpeterian entrepreneurial guys. On the other hand, we also have the false negative risks. Inaction can take the emergency of durable and non-contestable market power in these markets. When you look at this report from Lina Khan, they are really very hostile to big techs. I think they're too hostile because they just look at the false negative risks, not to the false positive risks. And the problem of public policy is that when we want to reduce the probability of one of those risks, we rise the probability of the other risks. So we're never in the best of the worlds. We have trade-offs. That's the point. That's something that economists love to insist all the time. And the case of self-preferencing, I think it's more where if you think about, let's think about Apple, our cell phone on Apple, our iPhone. iPhone makes a lot of self-preference when they install their own apps, the Apple apps, in the iPhone. They do it. So they are self-preferencing themselves. Is it bad? Is it every time bad? I don't think so. I don't think so. Why? Because I'm very lazy. I like to have the apps installed, first installed. I don't want to consider other apps sometimes. Sometimes I will try to install other apps, but I'd like to be a basic set of apps pre-installed, and they work. They work with the operational system in the very fine tuning. They don't break a lot of times because they were done one for each other. That's like a wedding. It's efficient from the consumer point of view. That Pfeiffer likes a lot. I have to put consumer because otherwise he fights with me. But it's from the economic perspective, from the consumer perspective, it's really very nice. So if we're are we going to ban this sort of conduct? We're going to say no. You have to deliver your iPhone without any app at all. I think it's unthinkable. I don't think it makes any sense. So we have to be very careful about this sort of conducts, and not to say we have to. Well, when you look at the self-preferencing on DMA, I feel scared about this. I don't know how far the regulator can take this sort of obligation. Anyway, the case of enforcement of non-discrimination provisions. We have friend provisions, non-discriminatory. Everything have to be equal between how you treat your own adjacent market and the yourself in the adjacent market and other competitors in the adjacent markets. I think that we also have to pay a lot of attention to implement, because moral hazard is very hard, is very difficult in this market, because it's much more difficult than in infrastructure, because we are dealing with algorithms, with does it discriminate, the algorithm discriminate against everyone else in favor of myself or not? To observe and to verify about this, it's much less trivial than in any infrastructure sector. And even in an infrastructure sector, this sort of discrimination, to apply discrimination provisions is also very hard. But in the case of digital market, it's much more hard than in the case of infrastructure. So the risk that we are committing a false positive, so to conclude that it's bad for competition, it's bad for efficient, when it's not, when it's good, it's about innovation. It's something that is really very risky when we talk about this. In the case of the apps, taking the example of the apps, non-discrimination should imply that the company should install every competitor app of Apple Music, for instance. Should we do it? How many Apple Music competitors you have, rivals you have? 10, 20? So I'm gonna fill the iPhone from Bianca with a lot of music. I don't know. She loves music that much. Perhaps she loves maps. She likes other apps. She wants to open space for other apps, not only for music. So I think it's a very, very difficult regulation. I'm not providing answer how it is gonna be, but I think it's something very difficult to do. Or anyway, should we create a universal search screen every time we enter in the app for all other apps in this segment? For instance, I was seeing the Walk of Santiago 1 year ago. And we download the Google Maps for my because I didn't think the Apple Map was as good as the Google Maps. But anyway, when I open the Apple Maps, should I suppose to open a search screen at some time? I don't think it's going to work that well. So there are many questions we have left behind. But well, the bill that I'm accused, 2768 from Deputy Congressman João Maia, operators with essential access power control. I think I agree with the gross revenue 7 million reais. I think it's too low, and perhaps we're supposed to think about number of users and the qualitative criteria from the EMA. I think it's a very good thing perhaps to bring it here and to think more about this. And I think this sort of discussion is good for us to think about this. I didn't have realized until now that there are per se obligations. The transparency and supply of information is economic treatment. When you read the bill, it's per se. And I was thinking when we write this about optional, depending on the case. And it's really something that we have to think about, to put it optional. Just examples of possibilities they're supposed to do. That data portability, interoperability can be solutions for a lot of cases, but not every cases. And you have, of course, the problem with data protection, that you have to be very careful about this, even considering the case of the paradox of the data protection, that nobody really cares when you dial on the when Apple asks to you, are you concerned about this? Otherwise, you can't go ahead. So no, I want to use it. So I just don't care about this. They call it the paradox of privacy of data. Nobody cares. In the final decision of the consumer, he really doesn't care about this. Anyway, the fact we put some technical criteria, isonomy, proportionality, cost-benefit analysis. Most of these are in the of the law of regulatory agencies. So we just try to repeat this here. We try to put something about responsive regulation, but I think we should develop a little bit more on this. And finally, I think that we could think a different approach to the regulatory procedures in the relation of digital platforms, and different from the ex-ante regulation. Ex-ante regulation is easier, of course. I just write a lot of don'ts, do's and don'ts that we're supposed to follow. But I think that we have an information, we are learning about this regulation. We know anything, we have to be humble about this. Not only us, all over the world. Nobody knows anything about this sort of regulation. We know something about infrastructure and to access, regulation of access, and it still is very, very difficult in practice. In this case, it's much more difficult. So I think, once more, I think it's very risky for an ex-ante regulation in Europe, United States, or in Brazil. The regulator starts thinking about a lot of do's and don't do's. I think it's really very risky. We are making some, como é que fala relatora? The relatora, the reporter? Well, the reporter congressmen are making some audiences about this, and I attended the first with people from Europe and the United States, and the main point of them is flexibility. We're not supposed to put the operators in a straitjacket. So otherwise, you would be risky a lot of efficiencies in the operation, and they are delivering a lot of benefits. Just think about the apps that you have here. It's very recent. It's from this century. We didn't have this. So we just want to give it up. Just say no. Doesn't innovate anymore. I don't want you to go to adjacent markets. I don't want you to self-preference adjacent markets. I don't know to make any coordination of your system with the other system to work better one with the other. I think we have to think really, really much more about this. And what do you have to say to do about this? I think we have to give it up from ex-ante regulation and think first it should depart from access seekers. The access seekers, who has trouble, who alleged to have trouble with gatekeepers. Just say, well, I have a proposal to improve access to gatekeeper to myself. And he submitted to the regulator, can be CADE or Anatel. The regulator should decide with a justification whether intervention is not required, or if it requires intervention. And at the same time, if he thinks that he requires intervention, he's supposed to offer some regulatory mediation for the access seeker and the gatekeeper. The gatekeeper could, if you have in this case of intervention, the gatekeeper is supposed to accept mediation or don't accept mediation. He can choose. If he accepts mediation, the regulator will start a mediated negotiation, providing space, even space to other access seekers in a similar situation. And the main point here is to hear, to listen what they have, what both sides have to say. I think it's supposed to be much more dynamic than what you do in CADE when we are negotiating. We just listen to the guys separately. They can't see each other. Now, it will be a negotiation. I will hear. I will listen to them. I will participate with them. I will be there with them. I will supervise. I will mediate as well. I think because we have to exchange information about the sector, about how it works, because we really don't know. It's very different from a port, very different from our railway, very different from local loop in the ancient local loop in the telecommunications. Very different from the transmission grid and electric power. It's completely different. We don't know this, and what's going on in each one of these segments. Amazon is very different. The access to Amazon story is very different from the Google search. It's completely different stuff. That's completely different stuff. And I have to understand very well about this. And I have a joke with Baigorre and said, well, we have to hire to the next concurso, the next exam for Anatel, have to hire the best hackers of Brazil or even from the US. Have to bring these guys to talk to work before Anatel, to be able to go inside and to realize whether there's discrimination, a bad discrimination, or something that is efficient, that improves the innovation that you're bringing to the market. Anyway, and after you start mediations, access seekers and gatekeepers can reach an agreement. Regulator can be included in the agreement to provide some enforcement, because they have to write like a contract, a regulatory contract, like the cease and desist order, or you do not reach an agreement. If you reach an agreement, the regulator would have the last say to define whether to extend this agreement or these provisions to similar demands through ex-ante regulation. He can make ex-ante regulation for who did not participate in the negotiations. He can do this because he learned about this in the negotiations. And if they don't reach an agreement, then now I will go to an ex-ante regulation. If I think, because I've already have decided that there's a role for regulatory intervention here. So the point here is that I'm offering some important space for the regulator to learn. And once more, he has to be humble. And you know that regulators are not humble at all. You know this, or you don't know? No, you don't. We were regulators, so he is a regulator. He cannot confess. I can confess. I can say this because it's my past. So, but anyway, sometimes when you're there, you want to say to know everything. You have this feeling as a regulator, not as a public policy manager. Sometimes you are quite embarrassed if you don't know how to do it. But you really don't know. We have to accept this. It's a fact of life. So the fact is, perhaps it looks complex. I presented this some time ago, and people have to handle this situation very fast. But the fact that we don't know what's the best solution for this case, because this case is really the information asymmetry of the regulator is the larger that I have seen in all of the sectors that I have studied in regulation. See, it's really very delicate, and my fear, I wrote this bill, but my really fear is that we are incurring in type 1 error, and you are just blocking some innovation, some very important innovation from incumbents. So it's really not. I just bringing more questions than anything at all. I'm so sorry about this, but I guess that we and the world. I think we still have to learn a lot about it. And we have some important cases in antitrust from the United States and mainly from Europe. I think they are more activist on this. And we have to learn from both, from the antitrust, and perhaps in this case, the CADE could have some, or the competitive action can have more expertise. But anyway, we have some idea from Bianca and Lucelena in a newspaper journal from some time ago, and something that I have not thought that you perhaps you could make something with bringing from different agencies, from the guy from the privacy agency, from CADE, from everybody, because just one agency, they don't know how to deal with this. You have privacy elements, competition elements, and perhaps this element that you say that's about you have a failure of the ecosystem, not a market failure. This difference, if you could advance a little bit, I would be very glad. Thank you very much for your attention.
Thank you very much. The presentations were really great. We learned a lot. I would like to address something that Cesar tell about the competition. It's interesting to observe, like we have a recent book from Nicolas Petit about mono-oligopoly, and where he discussed that we can observe intra-platform competition in which arises the problem of self-preferencing and competition between platforms. And the latter will probably be even more intense when platforms develop their AI systems to compete with AIs like ChatGPT. So I think that legislations like the DMA should address maybe only intra-competition, because we have a very level playing field between the platforms, and I think it will be a next stage of competition with AI and the systems of generative AI. And with the last part that Cesar made in the presentation, I'd like to address the questions for Professor Pfeiffer, Victor, and Malina. Following the adoption of the DMA final text, some have pointed to a risk of over-regulation, as we discussed it here. And we have this discussion in antitrust circles that the current instruments are no longer capable of dealing with digital markets. But we have already had some statements from CADE saying that our competition laws, by bringing the possibility of interim measures and settlement agreements like TCCs, they would be enough. So, as Cesar last said, I would like to know does Brazil really have to regulate it now, or can we be observing for a while how it's working in Europe and learn from that experience?
So I think that I have a lot to say, but first of all, I would like to make some comments about what Cesar has said before. And so first of all, I would like to clarify a little bit my initial comments in my presentation. The thing is, I'm not what I have thought that the DMA is not about market failures and is not about the traditional economic perspective attached to public utilities. That is, I'm not saying that this is the right vision. I'm not saying that from the perspective of a normative perspective. That is my reading of the legislation, and I think that there is the common reading that is coming up from several scholars. And here is why, and I would like to clarify a little bit about that. First, I think that we have to take a step back and try to understand what is the political movement and what lies behind this move towards a more regulatory approach in competition law. And when we see all the reports that has been released over the last years, the expert reports, the Siegel Center reports, and so on, we can see that they all point that there are some shortcomings, there are some flaws in the more traditional antitrust regimes. And one of these flaws is that antitrust investigations might be very time and resource intensive, and the antitrust remedies might not work for digital markets and so on. But when we see the DMA, it's very clear to me that the DMA is trying, and I am not saying that I fully agree with that. That is just an assessment about the reality. I say that the DMA is moving forward and is trying to get apart from the consumer welfare standards. And behind the consumer welfare standards, there is the traditional orthodox economics, which is the base not only for competition policy, but for economic regulation of public utilities as well. And for me, that is very, very clear in the DMA. So, for example, when we see the recital 11 of the DMA, it is pretty much clear in saying that Articles 101 and 102 of the Treaty and the corresponding national competition rules concerning anti-competitive and unilateral conduct, as well as merger control, have their objective of protecting undistorted competition on the market. That is the goal of competition law as such. This regulation, the DMA, instead, pursues an objective that is complementary to, but different from, protecting undistorted competition on a given market, as defined in competition law terms, which is to ensure that a market where gatekeepers are present are and remain contestable, fair, and independently from actual, potential, or presumed effects of a conduct of a given gatekeeper. So the DMA is pretty much clear. It is not just about competition only. And I think that's the point. This is some kind of a new form of public interest regulation, a new form of industrial policy regulation, I would say. And when we see the recital 23, that becomes even more clear. It is said in the DMA recital 23 that any justification on economic grounds seeking to enter into market definition or to demonstrate efficiencies deriving from a specific type of behavior by undertaking providing core platform service should be discarded, as it is not relevant to a designation as a gatekeeper. So here is pretty much clear. We are done of traditional neoclassical economics. And that was a political decision that was taken by the European Parliament. I'm not saying that we must embrace this perspective fully, but what I'm trying to say here is that I think that we might be very cautious about bringing a DMA-like legislation to Brazil and not saying what is the perspective, the economic policy perspective that we are adopting here. And finally, I'm sorry for reading this because, but I think that it is very important. And what I said about a digital ecosystem is that behind the DMA is a new kind of economic reasoning, in the sense that we are understanding that there might be a new form of economic power in the hands of the gatekeepers. And this new form of economic power might be very different from the traditional notion of market power, which is traditional the ability to set prices over the competitive level. So first of all, we don't have prices here, but the fact is that this very traditional notion of dominance, which is put forth in competition law, is much more concerned with horizontal competition. So even then, when we assess some unilateral practice cases, just as vertical cases, at the end of the day, the main worry in competition law is to avoid exclusion. So that's the point. We assess vertical restraints, but from the perspective of the consumer welfare standard, saying that we are worried about exclusion. And that is not the point behind the DMA. And recital 33, for example, draws upon the concept of fairness. And it says that unfairness should relate to an imbalance between users' rights and obligations of business users, where gatekeepers obtains a disproportionate advantage. So it's about a balance between rights and obligation. That is pretty much not the perspective, the traditional orthodox economic perspective that we have in competition law or in economic regulation as such. So that's are my points. I think that this logic of the DMA of regulating the digital ecosystem is very different. And just to finish here, I think that and Bianca has mentioned it, the ideas of Nicolas Petit of intra-competition and inter-ecosystem competition. I would say that the DMA pursues both. in the sense that contestability, which is the idea that new entrants will pose new challenges to gatekeepers, might be related to a notion of inter-ecosystem competition. And on the other hand, the fairness perspective, which is this address to the imbalance between rights and obligations between the gatekeeper and the business users, is more related to the notion of intra-ecosystem competition. So there's maybe the DMA is very ambitious in addressing both perspectives. So those are the points that I would like to make.
Yeah, quickly, I'll just make a few points because I know we're running out of time here. I don't want to answer your question too specifically of whether Brazil should enact this type of regulation, since I'm kind of an outsider looking in. But coming from the perspective of someone who's worked on this in the US a lot, I think, though you make a good point that the academic consensus around this issue in the United States might not necessarily be there. I think actions speak louder than words, and the proposal in the US really is not going anywhere in terms of the legislative proposals, and even in the court cases, there's been a lot of difficulty from the FTC and DOJ in actually proving tangible harms and substantial market power in a lot of these tech-related cases. The Meta acquisitions case, the Microsoft acquisitions case, there just hasn't been a lot of success on this track. So I think that's something that's of note, and you do see innovation coming out of the U.S. tech sector. You have startups like OpenAI, which reached $30 billion valuation at less than a year after ChatGPT was launched. You have Meta, which is designated as a gatekeeper under the DMA, losing market share to TikTok in terms of content marketing and things like that. So I think that in that sense, we have chosen a path that is trying to support that, further innovation, doesn't want to stifle these companies, which they are getting pressure from outside sources, whether it be international competitors coming from China or startups coming from within the U.S. And making sure to not stifle that environment. I would say, for such an emerging tech economy like Brazil is an important consideration. Does the future of the Brazilian tech economy want to look more like the United States, or does it want to look more like the EU's? And what are the approaches that you kind of do to achieve that?
Thank you for the question. I would say yes. That is important to have an ex-ante regulation, but not as the only solution. Just as important or more important, it's the adaptation of the current tools to the peculiarities of the digital platforms. For example, understand the dynamic of non-price competition and to adapt the tools to assess the market power, for example, or the effects of a merger between two companies that are two platforms that are acting in no price competition markets. It's very important to adapt all the existing tools, because the tools are very centralized in price issues, for instance. Another measure, a very important measure, is to have a consultation of the competition agency to consult another bodies like Anatel, like all of the regulators to understand the market, and it's very important to have interinstitutional actions. But I think this interinstitutional action or the adoption of tools are not sufficient to handle with the problems of digital platforms. What's the main issue is the time. We have a very large amount of time to close a case. In merger, we have constraints of time, but in the conduct, not. And it's very years and years to close a case. And when the case is decided, even the conduct it not exist more, or it cause irreversible effects in the market. So it's important to have some kind of regulation ex ante. But I totally agree that it should be very flexible, because it's very hard to this is a very dynamic market, and one problem of, for instance, Article 5 of DMA is that they are looking for the past, only for the past. And I don't know if, I think it's very important to look for the past, even to prohibit some conducts that we agree that are against competition. But I don't know if, but we have to look for the future as well. And I'm very uncomfortable with per se prohibitions or per se obligations. Maybe it could be more flexible, but we have to make some guidelines in the law and I agree that we have more clarify how are the guidelines to the regulator. Now, we don't, if you have some kind of wide obligations or no clear obligations, it's harder the issue to the regulator, and we have asymmetric of information. It's easy in this market to capture the regulator, and but in my opinion, it's very important to have an ex-ante regulation.
Great, Professor. Thank you. And about this, the pressurization as the term that Cesar likes to use. Article 10 provides for obligations of transparency, isonomic and non-discriminatory treatment, proper use of data collected, and etc. It's a non-binding list, but Anatel can impose additional obligations, as for the bill, to prevent abuse. So maybe it's too much power for the regulator also, if it's too open. So Michael, would like to ask a question?
Yes.
Or a comment?
Let me just make sure that this is...
Oh, do you want to talk?
Yeah, let me talk this better. Okay. I'm going to take one of the prerogatives of the co-sponsor of this symposium to sort of interpose a comment at this point. Okay. I'm Mike Mandel. I'm the chief economist of PPI. Am I being picked up here? Okay. The gentleman from Anatel said something very interesting. He said, don't change a winning team. Very important, okay? Because when we look at the difference between the EU framework for regulation and the US framework for regulation, what we see is that the US framework for regulation is producing both faster growth and stronger job growth. So from the point of view of economic results, and I'm not speaking about the competition questions, I'm speaking as an economist at this point, from the point of view of the key benefits for consumers and benefits for workers, which is extremely important in Brazil. Okay. The American framework has turned out to be extremely productive and much stronger than the European framework of regulation. So that there's a report sitting out on the front desk there that I wrote about the Brazilian app economy that shows there's 428,000 jobs in the Brazilian app economy, up 54% since 2020. This is incredible job growth under the current system of regulation. And the question is, and you raised a very important point about type 1 and type 2 errors, okay? Well, the evidence that we have at this point is that the US system of regulatory framework, produces better results than the European framework. For example, if we look at productivity growth, the productivity growth of the EU over the last 3 years has been 0.7% per year. The productivity growth in the US has been 1.6%. If you look at the growth of the tech sector in the US versus EU, okay, information and communications, which doesn't include hardware, so I sort of is kind of weird to say the tech sector. The US is growing at almost twice the rate as the EU. So when we look at a country like Brazil, and we say, should Brazil lean towards the European framework for regulation or towards the US framework for regulation, which one is going to produce better results for consumers, and which one is going to produce better results for workers? I need to sort of make one interesting point at this point. I mentioned the app economy, and the next panel is about e-commerce. I'm going to sort of jump ahead just a little bit. E-commerce originally in the US was supposed to be detrimental to workers. Technology was supposed to displace jobs. It turned out that e-commerce generated 1 million new jobs in the US because there was a trend, because innovation enabled people to sort of shift shopping hours from the household to the market sector, creating new jobs at a higher pay rate than the old retail jobs. And we didn't lose very many retail jobs either. So what we're seeing at this point, which is extremely important for Brazil, is this consistent sense that the US framework for regulation produces better results for consumers and more job growth of good jobs. Now, I'm not going to sort of say that there aren't any issues. I'd be crazy to say that, okay? But I sort of look at the rush to adopt a European-style DMA before it has been demonstrated to sort of work, not just from the competitive standpoint, but from the economic standpoint, which is, of course, what we're interested in, as being kind of odd and puzzling. Because if I'm looking at job growth, the US system has produced better job growth with higher wages and more tech jobs than the European framework. So, I mean, I'm going to say a few more words about this on the next panel, but I figured since this is what the discussion was about here, that I would sort of take the prerogative as a co-sponsor to sort of jump in out of order. Thanks.
Thank you very much, Michael. We can spend all night discussing these matters. It's really good. I love it. But we really have to move on. I just want to make a teaser to Victor. Thinking about prices, when we see the Facebook decision in Europe, when you say that the privacy policy is an abuse of dominant position, maybe because it's a price too high for the consumers to pay to get into Facebook. So it's an interesting point of view. Okay, thank you very much for all of you that were here with us in this panel. And let's move for a 15 minutes coffee break, and we come back with panel 2.
So now we will start our second panel about e-commerce and labor relations. I will start just a minute. Mais incisivamente. Hello, hello, it's working? Yeah, okay. So if everybody could get a seat? Yeah? Okay, we start now our second panel. So, good afternoon. You are so very welcome. I am Maria Gabriela Grins. I'm coordinator of Legal Grounds Institute, and now we are talking about a little bit about e-commerce and labor relations. And first we will start with Professor Cássio Casagrande, and he will take a flight this night, so he'll be the first to talk just because there are some few concerns about the weather changing in the pathway for Congonhas. So I think everybody is here in São Paulo can understand this. So let me just talk about a little bit about Professor Cássio. Professor Cássio Casagrande is Labor Public Prosecutor Office in Rio de Janeiro, Doctor in Political Science and Professor of Constitutional Law at the Federal Fluminense University. Then after speak of Professor Cássio, Professor Michael Mandel will talk, and he is Vice President and Chief Economist of Progressive Policy Institute. And then we will hear about, with some words from Olivia Pascoaleto, professor at Escola de Direito de São Paulo, FGV Direito São Paulo. And then we'll talk about with Lucas Maria Pitoni, Vice President of Legal Affairs at iFood. So, Professor Cássio.
Good evening, everybody. First of all, I would like to thank the Legal Grounds Institute and the Progressive Policy Institute that are sponsoring this event. And I do it personally to Bianca Moliconi, who kindly invited me, called me to be here. It's a pleasure to meet you in person and also to participate in this seminar. I'm very, very proud to be invited to this event, and I'm very happy that I will share this panel with Professor Olivia, with Gabriela, with Dr. Mandel, and with Lucas Piccioni, right? Finally, I'd like to thank Professor Pfeiffer for hosting us in this prestigious university. I really love to be here in San Francisco, and I think the last time I've been here was before the pandemic, so I'm very glad to have this opportunity to come back here and talk to you. Well, I need Francisco because the computer keeps asking for his password. Francisco, it keeps asking me for your password, so I don't know your password. 7360, okay. Will you remember this number? Okay. Well, I had prepared this PowerPoint yesterday, and I sent to Francisco. And but this morning I had to change it because the seminar is about digital economy, but it seems that digital is not working today. It was working. It was working. Esse aqui. Yeah. Ah, você quer pôr a tela toda? Entendi. Agora não está na tela toda aqui, tá? Okay. So let's start again. Well, I was telling you that I prepared this PowerPoint and I sent it to Francisco. But this morning I was taking my son to the school, and I dropped him, and then I was going back to my home, and I noticed there were two young men riding iFood bikes, and I said, well, I will talk about them today. So I was in the red light, they were passing by, and I took this photo. So I said, I have to change it because this photo was made today, this morning, in Rio de Janeiro, around 7:30. And look at them, two young boys. They are black, very young. They are poor, and I know they are poor because they don't have even a bike. You can see that these bikes are from Itaú. I think you have these bikes here in São Paulo, are rental bikes. So I was thinking about them, and they have very humble clothes too, and they are riding the bike with flip-flops. They don't have helmets. And this is very dangerous. I ride bike, I like to ride bikes, and it's dangerous to ride bike with flip-flops and without a helmet. And they have this bag where they put the food for delivery. So I would like to ask you if these guys are businessmen. Because during the last government, the executive, when Bolsonaro was president, passed executive order saying these guys are small businessmen and that they could pay for Social Security, taxes for Social Security from their pockets. But every week I go to judicial hearings where they are debating if they are employees or not. And I always ask these workers or former workers, did you pay any tax to Social Security? And all of them say no. Even those who suffered very serious accidents and were injured when working. So I also ask you, why should we call these workers digital workers? Okay, they work for the digital economy. iFood and Uber didn't exist before the digital revolution. And I am sure that they have created a lot of job opportunities. And I remember you mentioned that we have to look for good jobs. And I asked myself if this is a good job in the sense that they have, for instance, Social Security, if they have good safety equipment to do their jobs. For me, the answer is no. And why I am asking you if digital workers are so different from the traditional workers. Well, let's see the second image. Obviously, it was not me who took this photo. This I found in the internet. But, and don't ask me how they can ride this bike like this, very unsafety conditions too. But I ask you, what is the difference between them? Between these two guys who were working maybe 30 years ago or 40 or 50 years ago, and between these iFood delivery workers. They're doing the same job. It's the same job. They go to a restaurant, the iFood workers go to a restaurant, they pick up a food bag, and they deliver to the consumer. Is this work digital, virtual? No, it's a physical, it's a manual work, like those guys did some years ago. So the fact that they have a cell phone makes this work different, or is just work? This question is very important because we can have two approaches. If you think that, well, this is a completely new type of job and traditional employment law is not suitable for them, we have to look to Congress. We have here Cesar, who was talking about some possible initiative. You will be father of another regulation maybe that Congress would be dealing with this topic. But yes, if you say, no, this is a completely different type of job, so Congress should act and pass a special statute for these workers. But if you agree, this is my opinion, and this is the opinion of the labor prosecutor's office, if you say, no, in fact, maybe this is a different type of job, because you could not use an app to order food before, but not completely different from traditional jobs. So the current employment law can be fully applied with maybe only minor adaptations. So I think we have to start here. Depending on the answer, obviously, this problem will be delivered to political powers, if you think we need new regulation, or to the judiciary, if you think that, well, you can look for the laws we have and we will solve this problem. And what are the problems to be solved regarding those workers who are hired by platforms, let's say Uber, iFood, Cabify, etc. App workers are not assured constitutional social rights as minimum wage, overtime payment, annual vacation, maternity and sick leave. App workers are not protected by Social Security in Brazil. Food delivery workers in particular suffer serious accidents and lose their income if they are injured. The years they work are not being recorded for retirement. In the case of death, that is more common than we think, they are not assured pensions. App workers are not officially represented by unions and have no effective collective bargaining power. So, if app workers should be governed by a spatial statute, what specific rights should they be entitled to? I think this is what Congress will debate if Congress understands that a spatial statute is necessary. And should car hailing and delivery companies be considered responsible for the purpose of Social Security compulsory taxes? Because nowadays they're paying nothing, unless some of these bikers or drivers register in the Social Security. That's very, very low. So let's take a look. I will talk about what we are doing in the Labor Prosecutor Office, but before, let's take a look what are the executive and legislative branches doing here in Brazil. The executive response, I have talked about it during the Bolsonaro presidency. They classified app drivers as small businessmen, allowing them to pay Social Security from their pockets, as I said, without any burden to the companies. Now, as you know, we have a new government, and this government classifies app drivers and app delivery personnel as workers, and is stimulating a tripartite negotiation for consensus. But little progress has been reached until now. The government was trying to suggest a minimum wage for the hours drivers are logged in. But the companies, and please correct me if I am wrong, the companies don't agree with the value and want to pay only for the hours the workers are in fact in a right. So the negotiations failed, it seems to me, more or less. Maybe you can have more details, but I'm talking, I work in the judiciary, so what I'm talking is what I read in the news, but maybe, certainly you have more information about this. I know that things are very slow. And the legislative response, until now, app hailing cars are in Brazil since, I think, 2014 or something like that. And this is not a priority for Congress until now. We have a very modest proposition that was passed, this act that I mentioned here. But according to this legislation, companies have some duties regarding worker safety during the pandemic that is over. And I think they passed this law because during the pandemic, Congress passed a lot of laws to handle the situation. And it also, there's a provision to compensate for accidents, but only when they are in the premises of a warehouse or in the client's driveway area. This legislation does not deal with the worker's status. Now I will talk about my agency, my office, and for those who don't know it, which is the role of the Labor Prosecutor's Office regarding including these workers. The Labor Prosecutor's Office is an independent federal agency whose mission is to enforce employment and labor legislation in the courts. The Labor Prosecutor's Office is skeptical to the idea that the so-called digital jobs are a completely new kind of work. In its sense, digital workers, especially in the transportation and delivery industry, are doing their jobs under a company's control and direction. According to the Brazilian employment law, we believe they should be classified as employees because workers, in fact, sell their workforce through a platform. They have to follow strict rules set by the companies who design, own, and run these platforms. When these workers do not follow these rules, they are discontinued. That means they are laid off. I am telling you this not because I think this kind of thing happens, because we have an investigation and we have evidence that this is how things are. Their earnings are determined by the companies. If they were independent contractors, these workers would have the ability to bargain the right fares with their so-called clients. Imagine that you arrive in São Paulo and you want to know Pacaembu Stadium to visit the soccer museum. You can hire a taxi, you can hire an Uber, but you can call someone who was appointed for a friend that is a good driver, has a car, and he will ask you, okay, I'll take you to Pacaembu, and I will charge you 100 reais. I don't know if this is a good price. I said, no, this is too expensive. 100 reais for this ride, too expensive. He said, okay, let's do 90. Oh, it can happen. But he doesn't work for Uber, for another company, for another rideshare company. He's an independent contractor because he owns his car and he can set the fare. He can set the rate. He can negotiate with me. When I call Uber, the driver has no power to say how much his work worth. I don't understand how this could be an independent worker. App drivers and delivery workers cannot choose their so-called clients. Some companies say that they can say no for a request, but there's a consequence if they say no, I'll not take you to this place. They don't have any decisional power in the organization of their work. Companies' algorithms, and we study this very deeply, companies' algorithms are designed to pay workers according to the needs of the business. The companies will increase the fares in the areas where there are few drivers and decrease them where there are more drivers. So the worker, the driver, the delivery worker has no control at all. The fact that app drivers and delivery workers don't have regular shifts, and the fact that they can work for more than one platform, I call them employer, is not an obstacle to be classified as an employee, according to Brazilian legislation. I hear this argument. Company says, well, they can work, they can choose their shift. They can choose the hours they will work. Well, we can do this in home office. Isn't it? Who is lawyer here knows. You can work during the night, during the day. Someday you're not so good, you will work less or you work more, and you can be an employee. The fact that you have a flexible timesheet is not an obstacle to have an employment contract. And this is not new. And also, you can have more than one employer. According to Brazilian legislation, you can work for 5 employers if you are able to. If you can do it, there's no obstacle. You can work for Uber or for Cabify. 5 hours for one and 5 hours for the other. Well, let's talk about this class action lawsuits that I consider the leading cases adjudicated by the Federal Labor Prosecutor's Office. And you see that I write Uber and iFood. There are some other ones. These are the most discussed, debated. And you can also see that we have a blank sheet because these actions are still in the courts. In the trial court, the Labor Prosecutor's Office was, the decision was, the ruling was favorable to Prosecutor's Office. The judge said, yes, Uber drivers are employees, and Uber is appealing. They have still the time to appeal. In the case of iFood, iFood won. The judge in the trial court said, no, they are not employees for some reasons I mentioned. And we appealed. So don't ask me what's going to happen. And I think, obviously, I hope we will win. There's a lot of controversy about this. And people are asking, why this decision is being debated in the judiciary? Why not? The politicians should take care of this. And I answer you that this is happening all over the world. Some people are saying, oh, as we say in Portuguese, só mesmo no Brasil. But it's not só mesmo no Brasil. All over the world, this controversy is being adjudicated. And I mention here, your country, Professor, you know, maybe you will not like this, but Massachusetts sues Uber, Lyft over the status of drivers. And is the general attorney of Massachusetts, like the prosecutor's office here, who is demanding this lawsuit. I think the Massachusetts court still has a not final decision in this case. But in New York State, we have, in the Supreme Court of New York State, they debated a state law that considered these workers as employees. And the Supreme Court of the state of New York said, yes, they are employees, they have rights, like Social Security and like unemployment benefits. And this is happening all over the world, not only the United States. Well, I mentioned the 2 class actions that Labor Prosecutor's Office has adjudicated, but beyond that, there are thousands of individual, maybe there are some lawyers here who have these lawsuits, but there are thousands of individual lawsuits where these workers are pleading their rights in labor courts. Only here in Greater São Paulo, there is an estimate 4,000 lawsuits, and we estimate that in the whole country there must be something like 20,000 lawsuits where workers and companies are litigating over their status. And the thing is that we have considerable different rulings among all the labor courts, all the labor trial courts, and among all the labor appeals courts too. Some are favorable to workers, some are favorable to companies, and in some cases, companies are doing settlements. Our highest labor court, Tribunal Superior do Trabalho, has not until now reached a definite understanding or abiding precedent on the matter. Like it's happening in the inferior court, some panels in the highest labor court favor the workers' arguments and some do the opposite. Since in Brazil the Constitution protects workers' rights, the controversy may reach the Supreme Court. The current justices of the Brazilian Supreme Court have been very conservative about employment law in the last decade, so we are aware of this and a little bit worried about it. Well, let's say that the judiciary, in its final decision, would accept our argument that these workers are in fact in place. What would happen? Well, every time I read about this theme in the press all over the world, in the United States, in Europe, delivery corporations argue the same thing. Employment classification will heighten the fares for consumers. I agree. Extinguish jobs and even ruin their business. Very dramatic. So they may leave the Brazilian market. Well, such threats have been made in other places, where regulation has classified app workers as employees, like Spain and Germany. And what happened there? Or even where special statutes were passed to assure minimum wage, overtime payment, and some kind of insurance or social security, like England and New York State. So what happened there? Did Uber left these markets as they had threatened? No. In these places, Uber, for instance, ceased operation in some very few small cities. It's true, but did not leave at all the national market. Uber adapted to the new regulation. In fact, where employment regulation was adopted, fares for consumers heightened. But we should ask why they were so cheap before the new rules. The answer for me is crystal clear. Workers were underpaid, and Uber was holding the lion's share in the rides paid by its clients. This is a real problem of real people, of real life. These drivers are dying when they work, and they have no social security benefits. 2 weeks ago, in the city where I teach, Niterói, that it's across the bay, a Uber driver that didn't know the area mistakenly went to a favela where there is a gang who thought he was a member of another gang, and he was murdered. I ask you to go to Google, and you Google Uber driver die or Uber driver murdered. You will see how many events like this are happening. Or if you Google iFood biker, iFood motorcycle driver crashes and dies, or has serious injuries, you will see how many news like this you will find. So this is urgent. We are acting with the tools we have because we think the legislation, in fact, can be applied. But I think the politicians should act too. And this problem is urgent not only in Brazil, also in the US, and was debated recently by the presidents of both countries. Before you have second thought, this is not political propaganda for the Democratic Party or for the Workers' Party. It's just news because 2 weeks ago, this photo is for 2 weeks ago. It was not me who took it. They signed out a joint initiative to further workers' rights in international forums. So you see that I a little bit relieved that at least in the executive branch in the US, in Brazil, they are aware that something must be done. And this problem of digital workers is mentioned in the document as one of the very serious problems we have to face. So thank you very much, and I am here to answer any question you have. Thank you.
Thank you, Professor Cássio. And now we will hear something about Professor Michael Mandel.
Thank you very much. Is this one on? Or do I want to?
I don't think so.
I'll take the other one then, even though this one kept falling. Okay. Thank you very much for that very enthusiastic presentation. This is actually a subject that I've written about in the past, but I want to take a step back and put it in a larger framework. First, I want to sort of recommend to people that they pick up a copy of the paper that I wrote about the Brazilian app economy, which is their copies that are available out on the front desk, okay, which I need to sort of say that that our analysis of the app economy intentionally does not include Uber drivers or iFood deliverers. Okay, it does not include the second tier down. When we talk about the app economy, we talk about app developers and other sort of digital workers. What I think about the workers you're describing is digitally enabled workers. Okay. Yes. Digitally enabled workers are sort of becoming increasingly common. They're people that sort of have learned how to work with technology to create new jobs and improve the quality of the jobs that they have. Digitally enabled is, okay, just checking. All right. So what we've learned in the US is that technology has created not just app developers, I mean, it's created enormous numbers of app developers, both in the US and in Brazil. Okay. In Brazil, we've got 428,000 workers in the app economy, which is almost as much as South Korea. We don't have good figures on the number of digitally enabled workers. That's the ones that you're concerned with. We don't know for Spain and Germany how many jobs were lost when these regulations were introduced. We do not have the counts. We do not know whether or not that there was 100,000 or 50,000 or 150,000 people who would have had work before who do not have it. All right? So that data just doesn't exist at this point. So that we know, what we know is that the availability of the apps creates new opportunity for creating flexibility in work that did not exist before, creating new types of jobs, leaving aside the question about what sort of regulation that might have. They are new types of jobs because people were not doing them before. Just like you had, I mean, I won't even talk about iFood, I won't talk about iFood delivery, I'll talk about e-commerce delivery, okay, of products, which is that it's grown enormously in the US, creating jobs for people with high school educations that did not have them before. So that what we're looking at this point is really the question of what is the right level of regulation that would not get in the way, not just of the existing jobs, but of new jobs that might be created in the future. So if I look at a country like Brazil, what I'm asking myself the question is, what are the new industries? What are the new jobs? What are the new companies? How can we avoid getting in the way of growth? I mean, I'm not going to say that there may not be a reason for sort of regulating health and safety. I mean, historically speaking, when we've had new technologies, you've had the growth of the technology, you've had the growth of the jobs, and then what's happened is that people figure out what the problems are that they need to sort of deal with. Right? So I'm not saying that, but what I am saying is that attempts to sort of regulate in ways that raise prices, that cause companies at every level to sort of have less incentive to innovate, is especially problematic for a country like Brazil, which is trying to create more growth. In the US, I'm going to say a couple of words about e-commerce in the US. Right? In the US, when e-commerce was first growing large, there was big worries about a retail apocalypse. Does the word apocalypse translate? Okay.
Yes.
It's the retail apocalypse into sort of wiping out retail jobs. But what it turned out was that the new jobs in e-commerce fulfillment centers and delivery paid 30% more than the old retail jobs, and the old retail jobs were still around. And so it was a plus for consumers, and it was a plus for workers. The question that I need to just say one thing about that second, not the picture that you took, but the other picture, okay? I'm an economist, but I'm also an ex-journalist. And when I see a picture that looks too good to be true, okay, the first question that I asked myself was this posed? Okay, because if you can't see how it would be done, maybe it wasn't done the right way. All right. So what I would say, without getting into sort of the details of what the right level of regulation is, that I would not look at Spain and Germany as these great examples, because Spain is struggling at this point, and Germany has slow productivity growth. And these are countries which are trying to understand how to sort of innovate in the digital era. And just like I mentioned before, the European framework for regulation may not be the right one for Brazil when you compare it to the US framework. And now, as you pointed out, the US is wrestling with these questions too. Right? It's wrestling with them at the state level, it's wrestling with them at the local level, it's wrestling with them at the federal level. But I would suggest that not just in competition policy, but in labor market policy, that the US, which has had very strong job growth, very strong productivity growth during the pandemic years, is a better regulatory model for Brazil than Europe is. I understand that the European model, we were discussing this in the break, okay, is more attractive to lawyers, okay? It's straightforward, it's prescriptive, okay? I'm not going to say who told me this, okay? But I've seen this in the U.S. as well, okay? The European regulatory model is more attractive to people who like clear directions, who like things to be clear. The problem is that innovation is messy, innovation is uncertain, innovation requires giving people more freedom to make choices, even if you don't necessarily agree with what those choices are. And so what I would ask, and I'm going to leave aside the question of health and safety, which is a concern for all of us, okay? I would sort of ask if I went out and I sort of polled the workers, so I got a random sample, okay? What would the answers be? And I know what the answers would be in the US. The answers is that, as you might expect, the people who are doing this sort of job like doing it. They like the benefits. They like the flexibility. You can ask them these questions. They like the ability to stop and start when they please, to sort of work full-time some weeks, to work part-time other weeks. In the U.S., if you were working a full-time job, you couldn't do that, even whether you're working at home or not. It's not so much the what times you work, but the amount that you work. So the ability to turn down certain jobs. So what I would say is that this is a philosophical question as much as anything else, right? About which economic regulatory model Brazil would like to follow. The European model, which is Europe, as you know, is a slow population growth region, okay? And Brazil is much closer to the US in terms of speed of population growth and the need to generate more jobs. You generate jobs with innovation, you generate jobs with the willingness to experiment. And if you need, and at the end of the day, if you need to sort of address certain health and safety problems, you do that. But you do it in a way that's targeted and doesn't bring you back to sort of a previous regulatory framework. And that doesn't apply just to sort of e-commerce and the labor market, but it applies to the competitive issues we were discussing earlier. It applies to sort of a wide range of policy issues that, you know, frankly makes an enormous difference to Brazil, because I see in terms of innovative ferment, I see Brazil as being much closer to the US than to Europe. So thank you.
Thank you, Professor. And now, Professor Olivia.
There's no problem. So, good afternoon, everyone. First of all, I'd like to thank all the organization for this invitation. And I need to say that you were really professional and organized in conducting all the emails and information and social media. So thank you very much for everything. It's an honor to be here. It's a pleasure to debate with these great colleagues here in the panel, one of the most important issues of the world of work today, not only Brazil, but globally speaking. First of all, I would like to share, I'm not sure if it's possible now, but what's the roadmap for our conversation today? And I would like to start with some brief words about the digitalization and labor market, then go deeper to gig economy and app-based drivers, and finally talk a little bit about some challenges and opportunities in the regulation. Beginning with my first point, I think that it's important always to remember that we are in a moment that the diffusion of digital technology is reshaping the world of work. Of course, we are discussing today the app economy, but the world of work is not changing only because of that. So we can think about some examples of that. For instance, the popularization of teleworking, especially after COVID-19 pandemic, the increase of international jobs. So, for example, it's totally possible here for a person based in Brazil works for a company in India or United States, and it's totally common and even more common probably in the future. Also, we can think about the emergence of new jobs and new type of jobs, and we can discuss if it's new or not. And of course, one of the biggest concern of these days, the discuss about automation, about data protection, and also why not to talk about professional qualification in this scenario. These examples, I understand that they illustrate how this topic is much more complex and larger than talk about app-based drivers and delivery workers. But of course, they are really important, but we are talking about a larger scenario. And also, I believe that it's important to mention that this transformation, of course, brings us a lot of opportunities. For example, avoid the traffic in the bigger cities when we are working remotely. But at the same time, it brings us new challenges. For example, we were discussing here, for example, the contribution to social protection when we talk about iFood or Uber drivers. But if we think about workers who work internationally, it's even more complex because we don't know to what system we need to contribute. Just to mention some examples that I believe that we need to talk more about this transformation of the world of work and go beyond the gig economy. But as I said today, our main topic here is the gig economy, which is a really popular term, but it's not a consensual term. We have different definitions for this expression, but I really think that the following definition that I will read here give us some idea what is happening in this gig economy. That is called a growing economy characterized by flexible short-term contracts in which work is on demand, remuneration is defined by task, and worker is normally classified as a self-employed. And I believe that it's important to remember this definition because it gives us the main issues about this discussion. For example, the time, the limit working hours, the rests, the undefined remuneration at the end of the month, for example, and etc. So, considering this definition, I'm considering that this kind of characteristics impact our debate. So, one of them is the misclassification of workers. Yes. Okay. We are sharing with our virtual audience, but we are not able to share here. But there's not problem. So as I said, when we think about gig economy, of course, the first image that comes to our mind is the transport workers and delivery workers, for example, Uber and iFood workers, that are the symbols of this economy, but I also want to highlight that they are not the only workers of this economy. When we think about this growing economy, we need to understand that it's maybe a new way of contracting, a new way of acting in the labor market, and it involves different kind of activities. We conducted a research at FGV, where I teach, and we mapped around 17 kind of activities and more than 100 apps that connect a worker and the client. And of course, considering that, you can imagine the diversity and heterogeneity of this economy. So we can imagine, for example, that today we have transport by apps, delivery by apps, but we can also ask legal services by apps. We can also ask medical health services, care services, beauty services by apps. So this is the complexity that we are talking about. Of course, maybe the emergency to regulate and to discuss are related to workers in Uber and iFood model, but they are not only the giga workers, we have much more of this kind of economy around our labor market. So, what's the scenario in Brazil? What's the profile of workers? What are the apps? How do they work? And to answer this question, I would thank you, Professor Michael, because he said that we don't have too much data about these issues. And it's true, in Brazil, of course, we have some important information. For example, according to IPEA, that is an economy institute of research, applied research in Brazil, we have around 1.7 million people working in the gig economy in the transport and delivery sectors in Brazil. This is an important data, but it's an estimation. We don't know if it could be much more than this or less, but it's something around 1.5 million. Another second important data that is totally connected with your concern, Professor Cássio, that according to IPEA, again, we have of this more than million, only 23% of them contribute to social security. What is a kind of a problem here in Brazil, because if you don't contribute to the social security system, you are not able to receive social protection, especially, for example, the retirement, for example, some benefits when you have an accident, for example. So it's something that we are very concerned, because there are many people working, but the social protection is not covering most part of them. And recently, we have some researches that were conducted by Datafolha Institute and SEBRAP Institute that try to describe the profile of these workers. And it's interesting because, again, the results shows that we have a kind of diversity. It's not that easy to describe what are their needs and what and who are them. Well, considering what we know about the app-based drivers, it's a little bit more than the other workers, but it's not too much. But what we know is that these workers are the most popular workers in the gig economy. And I would like to highlight that it's my perception, but not only my perception, because when we look to the legislative debate, it's possible to understand that our first concern here in Brazil, it started with drivers, like in the Uber model. So the first bills that we have in some law that we have deals directly with drivers. And then, but especially after COVID-19 pandemic, the delivery workers gain a lot of attention in the debate, because during the pandemic, of course, everybody knows that all the restaurants and other bars and hotels were closed here in São Paulo and in all the world. And these workers provided us this possibility to be at home. So my perception is that after pandemic, this topic gained a lot of attention. And it gains too much attention in the society. So you can see, but I would like to show after I can share this presentation with you, that we have different actors discussing these topics. For example, today in our courts, we have different decisions about this issue. So Professor Cássio also mentioned that in some case Uber wins, in other case iFood wins or not. So we have a great debate in our courts, in the jurisprudence, and I would say that this is not good for anybody, because I always say that if a person asked me as a labor lawyer, what do you think? If I, for example, go to the labor justice, would I be considered an employee? And I can say, I don't know. I don't know because depends on the court, the case, what are you doing. So we have this insecurity, and it's shown every day. We start to read, for example, some papers, some newspapers, and every day we see different positions and different decisions. Of course, this is not a debate only in the courts. We have a great literature debate. We have this discussion, a great discussion in the legislative power. Of course, we have also this discussion, for example, being done in the International Labour Organization, in the governing body of the ILO. So this is one of the most important topics nowadays. And also we have a kind of social commotion, and I would like to show, but it's not possible now, but we have around the city some street art, some graffitis here in São Paulo, representing some gig workers as iFood workers or Uber drivers, just to give you an example of how this topic is being debated around and by different actors in our society. But now I think it's clear the problem that we have and the insecurity also that we have and the lot of doubts that we have. And I would like now to talk a little bit about the regulation, beginning with what we have. So we have a national urban mobility policy that in some sense recognize the possibility of this activity some time ago, since 2018. Then we have some municipal laws. For example, here in Brazil, in São Paulo, we have a law that deals with the bike drivers of the gig economy. It's not specific related to conditions of work, but in some sense deals with these people who ride bikes and not motorcycles. We had a law during the pandemic, and it's something that shows for me how the topic is difficult and maybe we are not so close to solve, because just to give you an example, we have this law during the pandemic that was approved in 2022, and this law number is 14297, stated that platforms should give, for example, masks and alcohol to delivery drivers and some other provisions. And this law was derived from a bill from 2020, or in other words, from the beginning of the pandemic, but we took 2 years to approve this law directly to delivery workers, with a scope really restricted to the pandemic. And when it was approved, we had formally the end of the pandemic. This is to show how it's difficult to deal with the topic. And considering now, not what we have, but what we are trying to have, I would like also to mention that we have a lot of bills in the Chamber of Deputies and Federal Senate. Just to have an idea, during the COVID-19 pandemic, just in 2020, we had more than 70 bills dealing with gig workers in general. So we have a lot of debate. But analyzing all of them, we can summarize the proposals in threefold. First of all, some of these bills are propose to characterize these workers as an employee, especially typical employee. So if they pass, for example, these workers would be considered an employee, and their relation would be regulated by our consolidation of labor laws. But also we have some proposals that try to characterize these workers as intermittent worker, as we call here in Brazil, but we can make the parallel to 0-hour contracts in other countries. But at the same time, we have an opposite kind of proposals, bills that consider these workers as independent contractors, as micro-entrepreneur or not. And these both bills, both kind of bills, deals with an important discussion that we have today, not only in the academia, but also in the labor courts, that can be resumed as if these workers are subordinated, are dependent or not to the platform. And also we have maybe a different kind of subordination, like algorithm subordination. So this is the main point of difference between the first and the second kind of proposals. And we have a third kind of them that characterized these workers in a third way. We also say here in Brazil, like the third option, or something that not take the opposites. And of course, this third way regulation, this third way kind of regulation varies according to the bill, but in general, they are proposing some minimal protection related to transparency, minimum wage, and some working hours and rest limits. Considering that, and I'm here finishing my presentation, I think I'm out of time, but I would like to mention that what we are seeing in our legislative power is not exclusive from Brazil. As professors also mentioned before, we had this debate, sometimes a very similar debate, sometimes with some particularities, but we have this debate and some options that were taken in different countries or cities, for example, in Spain, for example, in Australia, and for example, here in Chile, our neighbor. I always like to mention this example because it's closer to us, but when we saw all the debate that they have been done, the difficulties were the same, and there, for example, they passed a law that create two types of gig workers. One of them that really works frequently with this kind of platform, so every day, and the other kind of work who don't has this frequency. So sometimes just on weekends, for example, and etc. It's just an example to mention that we can be inspired by international experience, but of course we need to think about our particularities. But this kind of inspiration could help us to think about in new alternatives. And also, together with this, maybe this inspiration, I would like to mention other starting points that could help us in create and formulate this regulation. The first of all, that I always like to remember that we have from the ILO a Declaration of Fundamental Principles and Rights at Work that lists some minimal rights at work and not only at employment, so we can think about work more broader maybe. And some of them, for me, it's very clear, and I believe also for platforms that it's clear. For example, freedom of association. I believe that nobody thinks it's a problem. Everybody has the freedom of association. forced labor, elimination of forced labor, abolition of child labor, of course, elimination of discrimination. And the last one, and maybe is I don't think it's the most important, but one of the most important points here, especially after COVID-19 pandemic, that is health and safety at work, that was considered a fundamental right and principle at work last year from the ILO. So I believe we have here a kind of a guide to start to think about this regulation. And also, I would like to mention the idea of, and the notion of decent work, especially the decent work agenda, that mentions the importance of social security and, again, the social dialogue and tripartism. And I believe that, in some sense, it's what we are doing now, a kind of social dialogue here, but the idea that talking about together with workers, platforms, government, and civil society could be also an important guide to us. This is, I'm not sure if we have success, but it's happening now here in Brazil. We have a work group coordinated by the federal government that are talking with workers, platforms, and trying to connect and to reach a kind of consensus. So I believe that a social dialogue is important to construct a regulation that an effective regulation, but as we say here in Brazil, a regulation or a law that it's true, or a lei que pega. Right, because we want a regulation, of course, but an effective regulation. So, thank you very much. I'm totally available here for comments and questions, and again, thank you for the invitation.
And now, last but not least, Lucas Piccioni from iFood.
Hi everyone, thanks for the invitation. It's an honor to be here, sharing this panel. A lot of things to cover, a lot of things to debate. I'll try my best to not exceed 10 minutes. I know we are running late here. But let me start by saying that I am an optimistic, and employment status aside, I think we agree more than disagree. I think, and I intend during my presentation to, address most of the critics and most of the problems that were raised here. I do think we are progressing, and hopefully during the next few months we will have less insecurity, so that we can have more jobs, so we can make more progress in the economy and so on. So let me start by explaining a little bit what iFood is. I'm not sure if I know we have an international audience, so I'm not sure if everyone is familiar with the platform. So we are the leading food and groceries delivery platform in the country. I think that's the reason why our brand was mentioned a few times today. We launched our operations in Brazil in 2011. Right now we are present in 1,700 cities, serving 40 million customers and generating income to more than 200,000 careers on a monthly basis. If we expand this time frame a little more, if we look at on an yearly basis, we're talking about more than 500,000 careers working with the platform. It's also important to mention that iFood has two main business models. So we didn't start it as this traditional gig economy platform. In the beginning, iFood was a pure marketplace. That means that we were only connecting merchants to customers, and the merchants were the ones in charge of delivering the orders. That is still true for, I would say, 65% of the orders that are placed through iFood. Only 35% of the orders right now are delivered by gig workers. And this information is important, and I'm not mentioning this out of my mind here. This is important because depending on the regulation we have, we may create incentives for merchants to go from the full service model to the marketplace model because it will be cheaper. And we know for a fact that the relation between the restaurants, the grocery stores, and so on, with their delivery personnel, it's quite informal. So I think one of the concerns that we share with the federal government right now is that we need to create something that brings those 65% to the formalization instead of doing the other way around, that is pushing the 35% to the 65%. So I think that's important to mention. We are not threatening to leave Brazil because we're only present in Brazil. This is important because this sometimes is raised during the discussions. No, we don't have a plan B, so we are only present here. I have to say that I think in the beginning of this industry in Brazil, yeah, I think there was this discussion around, well, are the workers entrepreneurs? Are they businessmen? What are they? They are workers, we agree on that. We only believe that the work they do through the platform has certain specificities, certain particularities, and we need to think about regulation that takes those particularities into account. This is the position of the company, I believe, since 2019. So I think in 19 or 20, I think was the first year when our CEO published an article of opinion on Folha, the main newspaper in the country, or the most read newspaper in the country, and that's our view since then. Before I talk a little bit more about the regulation and our view on regulation, I think it's important to to once again mention the litigation background here in Brazil. So, well, we are a country known for its litigation. So iFood's part of a larger group. One of the investors of iFood, they are present in, I think, 70 or 100 countries. I'm not sure. And we account for 99% of the claims in the whole group. So, so yeah, we are famous for litigation. And right now, if I had to choose two words to describe the environment where we live in, those would be legal uncertainty, because we saw from the examples that were shown here, it's impossible to predict the outcome of a claim right now in the country. So at iFood, we deal with two main types of claims. So we have the individual claims, a few hundred of them, maybe more than 1,000 actually right now. And we have the collective claim that was filed by the Labor Prosecutor's Office of the State of São Paulo against the company. If we deep dive into those claims, the vast majority of the results, they go against the employment, but we do have certain decisions acknowledging the employment status. And worse than that, when it comes to the superior labor court, it's a matter of luck. When the claim arrives at the labor superior court, the claim is distributed, randomly distributed, and depending on the panel, depending on the group of judges, you know the outcome beforehand. So it's impossible to make business in that scenario, and that's also connected to the difference between the Uber and iFood decisions, the difference between the decisions in the Uber individual case and the Uber collective case. So, yeah, it's quite uncertain at the moment, and of course that doesn't help anyone, I think. The view of the company is that we are talking about a labor relationship, So we're talking about labors here, labor force and so on. We're not talking about employment, but we can deal with health, safety, working conditions, social security, without the help of the employment. That's our position here. And this is quite complex because, well, not all platforms have the same understanding. It's hard to identify who represents the workers sometimes. But I have to say that I think that the federal government is doing a very good job so far. I think the first point I would highlight is I think there has been a lot of social dialogue during this year. So back in the 1st of May, back to the 1st of May, a tripartite group was created. The government is dealing with the complexities of the representatives of the workers right now. So some unions, some local unions have some force and they have some legitimacy to speak on behalf of the workers. In other regions, YouTubers are the ones that represent the workers. In other regions, we're talking about associations. So even for the platform, there's a lot of uncertainty there because how can you map or how can you deal with those different groups of representatives if you don't know who really has legitimacy to speak on behalf of the workers. Also, I think when the situation is so complex, we risk being stuck and risk being in a situation where we don't progress. I think to address that, the federal government and the Ministry of Labor in particular, they did a good job to try to separate or to create blocks to discuss different parts of the regulation separately so we can make progress in parallel. And we are talking about fair pay. We are talking about the legal status of that work. We are talking about working conditions such as time limits and so on. And we are talking about also social security and social security contribution. I'll leave the social security as my final comment because that's the most complex one. And when it comes to the other points, I don't think, well, if you read the news, one would imagine that there's a lot of disagreement between the platforms and the government. I don't think that's the reality, honestly. I think that's part of the negotiation. That's how these things go. There's a lot of pressure. That's part of the work there. But I think when it comes to the legal framework and when it comes to creating a new policy, a new regulation, of course the government is taking into account the legal aspects of that relation, but also what the workers want. And I think, at least this is my view, probably others would disagree, but my view is that the government came to the conclusion that at least most of the workers, they do want to have something new that can preserve the flexibility that we mentioned before, at the same time that brings more rights to that relation. And so therefore, I do think that any proposal that is sent to the Congress will, within the labor code or not, will try to create a new category of work. That's my bet, I would say. When it comes to working conditions, and I think we can talk a little bit about health as well here, health and safety. Most of the platforms already provide private insurance against some of the issues that were raised here. I know that they are not enough, and I know that they need to improve. I do think that the regulation will address that as well, as the regulation during the pandemic tried to do so. I do think that there will be some limitation on the time that the workers can be connected. And also, I think there will be some discussion around having physical places where workers can rest, have access to bathrooms and so on. I think that will be there as well. When it comes to fair pay, we're talking about minimum wage here, right? So I think the whole purpose of the discussion there is to create something that allows the workers to earn a net income that is at least equivalent to the minimum wage in the country. So that means that regardless of the parameter that we choose, the platforms will need to pay above the minimum wage to indemnify the workers for the costs of their activities. And the news are also goes on towards that direction as well. I know that there's a big debate around worked hour and online hour here. I think the solution lies in between. So we see some examples about that. So for example, in Chile, we have the minimum wage plus 20% that is supposed to indemnify the worker for the time he or she spends waiting for an order to come. So I think that's part of the debate here in Brazil as well. I think there will be some adjustment to the minimum wage to address that. And lastly, there's the social security. And I'm leaving that aside because I think that's where we disagree with the government the most. So it's clear, at least to iFood, that we have to pay our part. And we have to pay more than the workers will pay to finance the social security system, to fund the social security system. The problem here is that we're not talking about a single profile of worker. And then I think the example in Chile, I think they were so successful in understanding that and creating different rules for different types of workers. So let's look at the example of iFood here. More than 60% of the careers that earn an income with the platform, they spend online, I'm not talking about worked hours, something between 40 and 60 hours a month. So their income is proportional to their time spent on the platform. Therefore, if we charge those workers in the same way the social security system was built in Brazil, they will probably not get to the minimum contribution that is required for them to be included in the social security system. Will this law be effective if we don't tackle this issue? I don't think so. And I think we are missing an opportunity here to do the same thing that we are doing in the labor side of the discussion. If we are creating a new category of work, we should discuss a new social contribution system here to make sure that all those workers are effectively included and not only taxed, because that won't please anyone. No one will be happy with that. And just as a final comment on the international landscape, yeah, I think Europe is going towards employment presumption. But I have to say that I spoke a lot with the executives of Spanish platforms there. And what I heard was that they had to, on the one side, limit their operations to those cities where they had enough orders to justify a full-time traditional employee. And in Spain, we're talking about Madrid and Barcelona. So they had to leave the other cities. Or on the other on the other hand, they had to outsource that activity, and that's a discussion. I know we don't want to have in Brazil as well, right? So outsourcing can also be a problem, and that's something that they are doing there. But I do agree that this is new, and we have to wait a little bit to gather data and see the externalities, the outcomes there. I like the example from Chile, as I mentioned before, because they decided to create a new category of worker, actually two categories of worker, or one category of two sub-categories. And they are giving more protection to those workers that earn their main income from platforms, and they are closing their eyes a little bit when they look at those workers that are simply making an additional income there because, well, they are probably part of another relation, another company. In the US, I think we have different examples there. So we have, for example, New York trying to regulate minimum wage only. We have California with a different example. We have, I think, Chicago also regulating minimum wage. Also in Europe, we have the UK going also to an intermediary way. So there we have the independent contractor, the worker, and the employee, and they are classifying the gig workers as workers. And we have, for example, India that is trying to tackle the social security discussion without tackling the other issues that we discussed here. There's a problem there because they define the rule on a federal level, but the state level needs to apply it, and they are not applying it. So it's a different problem there. But in the end, I think the message that I would like to leave is that, so I don't think this new category of work will replace the traditional employment. I think both types of work will coexist. And I think that we have an opportunity here to do for the gig workers the same thing that the labor code and the employment did for workers in the past. That is to include them in our society. So I once read a statement from Godinho, one of the judges in the Superior Labor Court in Brazil, and he said that when a Brazilian worker is hired and has his registry done, he becomes an economic individual. He's able to open a bank account. He's able to get a loan and so on and so forth. I think that's the same thing that we need to do for gig workers. I acknowledge that we have a lot of informality right now. I acknowledge that, well, the minority of them are contributing to the social security system. And also, I think we need to find ways to bring them to the formality, to open more work positions, and to include them not only in the social security system, but also in the economic life in the country. And that's the size of the challenge. It's not easy. I don't think that the debate will end with the federal government, because I think the idea is that the federal government will send a proposal to the Congress, and we know that it's quite hard to predict what will happen there. But yeah, but I think we have a window of opportunity here. We shouldn't miss this opportunity. That will be good for platforms because they will have more certainty. That will be good for workers, and that will be good for economy in the end. iFood itself right now impacts half percent of the Brazilian gross profit. That's the size of the gig economy right now. So yeah, huge challenge. Thanks. Yeah.
Well, so we would like to thank you all the speakers for the knowledge they shared with us today. And I would like to call Professor Pfeiffer, Professor Bernardo Fico, and Professor Malena for the final conclusions. Thank you.
Event. It's great to have such an engaged audience for these types of conversations, and these are such important conversations to be had in the international context. The international nature of these issues in the digital market space, it makes it so valuable to really give us the opportunity to learn from experts who are working in these countries and be able to have conversations about what's happening on the ground, because from a US perspective we don't always get that. So I just want to thank the Legal Grounds Institute for coordinating all of the logistics and the University of Sao Paulo for hosting us. I want to thank everyone who spoke today. Again, it's so valuable to be able to learn from your expertise. A special thanks to Bernardo, who we've worked very closely with on all of this, and really helped make this event a success. And thank you all for allowing us to kind of come to Brazil and share our thoughts on the digital markets regulation, our experiences, and also sharing your experiences with us. So thank you. It's been a great event.
Hi everyone. Can you hear me well? Okay. So first, I'd also like to thank everyone who came here and everyone who's watching us on live stream. I want to thank the Progressive Policy Institute for being so into doing this event with us and sharing so much and really fostering the debate. I also think that's very important that we get like different perspectives from different countries, because although not every time we're going to be able to really borrow things from one another, it's very interesting knowing how different countries are solving issues that are currently happening with everyone at the same time, and we don't actually have like this squared answer as to how we're going to approach this. So it's very interesting to see different perspectives being brought to the table. And also, of course, thanking the University of São Paulo for having us, for hosting us here. And the one thing I'd like to say regarding the event is that it's very nice to hear this open debate. We saw a lot of different and polarized positions even, but very open to actually discuss and debate this. And we, as Legal Grounds Institute, believe that this is the path to move forward. We don't want to have debates that are one-sided. We want to have everyone in the conversation so we can actually move forward with topics that are so important to everyone. So that's why we really cherish and we're very grateful for all the speakers that came here and had their positions and really argued for different points, because that's the whole objective of actually having a debate. So thank you everyone for coming. Thank you for the speakers and for the university for hosting us. Thank you very much.
So good night. And on behalf of University of São Paulo, I would like to reiterate the honor of having hosted this important symposium. Two important issues were discussed related to the main economic agent of electronic commerce. Oh, excuse me. Sorry. No problem. So I will start again. On behalf of University of São Paulo, I would like to reiterate the honor of having hosted this important symposium. Two important issues were discussed related to the main economic agent of electronic commerce, the digital platforms. It was demonstrated by the very high level of the debate that it makes perfect sense to be discussed at an international event, as not only because the platforms have a global activity, but the issues are discussed and debated all over the world. Regarding competition regulation, we could see that there is an intense debate about the best way to handle with the complexity of the the competition dynamic of these platforms. There are a trade-off between to regulate and not to regulate, and even if the country or the region decide to regulate, what kind of regulation? One more strict, more flexible. Personally, I do prefer the flexible regulation, but it's very important to discuss between us, Brazilian, because we are trying to approve a bill of law regarding the competition regulation, but it's very important to listen about the experience, the international experience. So it is very useful, and I thank so much for the organizers to have this opportunity to discuss among very experienced people. And so on, the labor relation between delivers and drivers with the platform is a very, very important issue. And it's an international issue because the characteristics of the relation between the platform and the delivers are very similar, but it can be a variety of solutions in the country. So it's very important to discuss because we have a bill of law and we have very decisions of the labor courts. So it was very useful. I'm very happy and very honored to host this seminar, and I thank you so much for PPI, and thank you so much for the legal grounds for invite USP to join with this initiative. So thank you so much.